So good morning, everyone. My name is Patty Griffin, ANSI's General Counsel, and I have the great privilege to welcome all of you to our annual Legal Issues Forum. This year, our discussion will revolve around two pivotal questions. Our first panel will address standards incorporated by reference into regulations, a topic that's been debated for more than a decade, but the discussion is even more significant now in light of the recent ASTM decision issued just a few weeks ago by the U.S. Court of Appeals for the D.C. Circuit. And that raises the question, what now? And does that decision change things? Our second panel will focus on the interplay of generative AI and copyright and what that means for standards developers. As many of you know, we spent the day on Tuesday exploring how AI might rewrite our future. Today's second panel, however, will more narrowly focus on what we all need to know about the use of AI in the standards world. What do we do when AI gobbles up our standards? And how do we educate our staff to responsibly use AI when they seek to develop new ones? To guide us through these discussions, we have a very impressive lineup of legal experts, industry leaders, and standards professionals. Before I introduce our keynote speaker, let me address one important issue regarding CLE credits. For those lawyers in attendance seeking CLE credits today, if you're here in person, make sure you sign the CLE sign-in sheet at the registration table at the beginning of the program. And if you haven't done it, you can do it at the break. But then go back to the registration table to sign out at the end of the program. And that's how we can make sure that we submit proper documentation to enable you to get your credits. If you're seeking CLE credits online, I will give you the code word at the end of this event in my closing remarks and explain how you can enter that word into the Zoom chat to verify your attendance. So let me get things started. It's a great pleasure to introduce our keynote speaker, Professor Carrie Colanesi. Professor Colanesi is the Edward B. Shills Professor of Law and Professor of Political Science at the University of Pennsylvania, where he's also the founding director of the Penn Program on Regulation. Professor Colanesi specializes in the study of administrative law and regulatory processes with an emphasis on the empirical evaluation of alternative processes and strategies and the role of public participation, technology, and business-government relations in policymaking. The author of more than 350 scholarly works, Professor Colanesi has also created a leading website for standards education. And prior to joining the Penn faculty, Professor Colanesi spent 12 years on the faculty at Harvard University. Please join me in welcoming Professor Colanesi.
Thank you very much, Patricia, and thank you for the invitation and opportunity to be here today. This forum is so very important because it brings together the world of standards with the world of law. This is a theme that I have been exploring in some of my own work, just published earlier this year, a paper called Standards and the Law in the journal Standardization, in which I showcase the ways in which standards weave their way into a variety of areas of law, certainly copyright, which is the focus for today, but not just copyright, criminal law, contracts, torts, environmental law, administrative law, international trade. So what I am heartened by are these conversations that we have here today, and what I've been trying to do with the curricular website, codesandstandards.org, that we developed with the support from NIST, is try to bring attention to the ways in which the world of standards intersect with the worlds of law. And I'm really honored very much to be here today to talk with you. I want to share with you three stories about three interconnected forces in the world: technology, standards, and law. And I'm going to take some time to go through each of these and draw out what I see as some of the lessons that they hold for the moment. Ultimately, in the last of the story, the most recent one dealing with artificial intelligence technology. But the three stories are going to be centered around DNA tracing, which is not a focus here, but I think is instructive. The second would be about incorporation by reference. And the third, as I say, is the unwritten story, the just even emerging story, really, of AI. In each of these, technology, standards, and law are interconnected. In some of these, technology is the real driver, law is a barrier, and standards help overcome those barriers. In others, though, the relationship is much more complicated. I think the reality is that in all of these stories, and maybe I should think about these as chapters in a novel, if you will, that we're living through and have lived through. Each of them is disruptive to the world of law and in the world of standards. I think, is going to be interesting to see where we go with artificial intelligence technology, whether the disruptions that occur ultimately are positive ones for the standards community and positive ones for society overall. I think with respect to the story I'm going to tell about DNA technology, standards were actually really instrumental in allowing this important technology that's valuable for society. In the IBR, or incorporation by reference story, it's less clear. And that chapter is still also being written about whether the disruption will be positive for society, what it will mean for the standards community. But in each, as much as we can focus sometimes in our spheres as lawyers in particular on what the law is, I want to argue that the law can't be viewed in isolation. It is a woven web between technology and non-governmental, voluntary, private standards and the law. Let me begin with the first chapter then about DNA. If one thinks about DNA technology today in the criminal justice system, one might say that it really has achieved the position of a gold standard for evidentiary purposes in criminal law. It's admissible, it's treated as highly reliable, it's the foundation for hundreds upon hundreds of exonerations. All 50 states are now giving defendants a post-conviction right to do DNA analysis of evidence. Where we're living today, or we're meeting today, right now in the DC District of Columbia, there's actually a pretrial right that a defendant has to have DNA analysis done. And in a host of civil contexts, DNA analysis is widely accepted and even required, such as in paternity matters. But it wasn't always so. It wasn't always so. In 1953, really, is when DNA technologies emerged. It wasn't until the 1980s that it started to be used forensically in the criminal justice system. It was 1985 when we saw the first use of DNA analysis to support a criminal conviction. But courts were still very wary in the 1980s. One law journal commented that this technology, quote, threatens our constitutionally guaranteed rights to procedural due process and individual privacy. A National Research Council report around the same time warned of the dangers of DNA tracing, expressing particular concerns about privacy violations. A New York trial court in 1989 held a 12-week trial, 12-week trial, just probing the reliability and ability to introduce DNA technology into a criminal case, ultimately determining, by the way, that the prosecution could not admit it. Why? Because the prosecution, quote, failed in its responsibilities to perform the accepted scientific techniques. Around the same time, a Minnesota Supreme Court in a famous case held DNA evidence inadmissible. So how did we get from that kind of skepticism in the law to a new technology? The answer, in large part, was from standards. The technology standards law connection with DNA turned out to be something like, technology plus standards equals law. It was really the standardization of forensic laboratory techniques that convinced courts and continues to convince courts that this is a highly reliable and important and highly probative source of evidence. So the technology developed, it faced an initial legal barrier, and standards helped it overcome that barrier. That ultimately is a wonderful case of disruption that resulted in positive good. So this is not to say that all issues surrounding DNA are past us, but I think by and large that chapter seems to be one we can turn the page on, and then turn to the second chapter that I want to talk about, in which you'll be discussing at greater length in the next session, the incorporation by reference. Now, incorporation by reference itself is probably as old as the law, and certainly incorporation by reference of standards, probably as old as standards and law together. The first real traces of the phrase incorporation by reference comes about, and if you look in the court reporters in the mid-1800s, largely in the context of wills and trusts, people incorporating by reference maps and lists into their testamentary documents. There was also in the late 1800s an interesting set of cases about incorporating by reference older statutes into newer statutes. Some state constitutions had a one subject rule that was designed to encourage legislatures to adopt all that was needed to understand a statute into that statute at one time. And then there were questions that emerged about incorporating by reference other prior statutes. But incorporation by reference of private standards in public law was something that really was widely accepted for many, many years. The 1966 FOIA amendments allowed agencies to incorporate by reference as long as those incorporated standards were reasonably available to the class of persons affected. Congress recognized the practice of incorporating by reference standards. Congress not only recognized this, Congress sometimes compelled it. Here's a part of our history that I think sometimes gets lost. The 1970 OSHA Act, Occupational Safety and Health Act, it not only authorized OSHA to incorporate by reference voluntary industry consensus standards related to workplace health and safety, it said, do it, incorporate any of these. And by the way, OSHA, you can do that by going around the notice and comment rulemaking process entirely. And so OSHA in 1971, 72, 73, they had about 2 years to do this, incorporated by reference hundreds of industry workplace standards, doing so without even any notice and comment that we think of as part and parcel of the rulemaking process today. And then, of course, as probably everybody in the room knows, in 1996, Congress passed the National Technology Transfer and Advancement Act, which is sometimes called the National Technology Transfer and Advancement Act of 1995, even though it was actually signed into law in 1996. But be that as it may, that compels agencies to look at existing standards before creating new regulations and to choose those standards whenever feasible and in accordance with law. So we have, instead of the kind of litigated controversy that you're going to be talking about today, we have in the beginning of this chapter an embrace of standards in the law. And what is disruptive is the development of technology. If we didn't have the internet, if the only issue was somebody photocopying some copyrighted standards and sharing them with a friend or so, we wouldn't really be having the kind of conversation that we're having today. But it was interesting that really it wasn't until right around the time that the NTTAA was adopted by Congress that that was the emergence of the internet as we know it today, the World Wide Web. Government agencies in 1996 hadn't put many things up on websites. Not all agencies had websites to the extent that they do today. But because that technology afforded agencies to create websites after the NTTA, after that embrace, we now have been grappling with ever since the question of what reasonable availability really means. And we have a variety of court decisions that have emerged since the Veek decision in the Fifth Circuit in 2002 and up to the DC Circuit decision 1 month ago today, and more that's on the horizon and in the works, in which courts are now grappling with what does it mean for copyrighted standards to be made available to the public when they have been incorporated by reference. I think if one looks at the rulings to date, it would seem that the law here is prevailing over the standards community's claim to copyright, and fair use is being generally found for those who want to put up incorporated standards, even though they're copyrighted on the internet. Why? Because this technology has changed what it means to be accessible. A June decision this year denying a preliminary injunction against upcodes in the Eastern District of Missouri, the court said that the public interest in accessibility of standards adopted into law weighs in favor of upcodes and against enjoining their action. Think about that. What has been defining accessibility has been technology itself. So this is another example where technology, standards, law are intersecting in interesting and important ways. Now we get to the third chapter, the one that you'll take up in your second session about AI. And we're just beginning, I think, to see some of the early first drafts of this chapter. Machine learning certainly has been around for decades now, but it's only with the advances in computing power and the advances, the availability of the large amount of data that is on the internet. And by the way, it's kind of interesting when we talk about the internet here. The internet is also another technology that would not have emerged but for standards as well. So we have another technology, AI, making use of data on the internet. We see the pace of change being so dramatic. ChatGPT, when it was introduced in version 3.5 in November of 2022, passing the uniform bar exam? No, couldn't do that, 10% score. But by March of this year, ChatGPT version 4.0, passing the uniform bar exam, essay questions as well as multiple choice, no problem, no sweat, 90% level passage rate. The pace of change is itself transformative in so many different ways. Some of the most immediate ways are related to what you'll be talking about later today about copyright. Here, one of the questions is likely to be, can copyright of the standards then protect standard-setting organizations from having these large language models analyze and use and process their standards? But that is, in some sense, the question that everybody, I think, is asking about their own copyrighted material. What might be a more distinct question emerging is whether AI can be used and should be used to create standards, to create a new essential requirements process that's automated and in which we have a standard setting by algorithm. Maybe we need that. Because of the fast-paced change of the technology, we need to match it with a faster pace change of standard setting. Will standards that are developed through AI be themselves copyrightable is a question certainly to be asked as well. It seems at this point in litigation and in guidance from the Copyright Office that the answer is no, because it's not human generated. But maybe we'll see that there's some ways of incorporation by humans of AI developed standards that will be deemed protected in some way. We'll have to see. I want to just bring it back full circle because if you remember the start of DNA technology when it was being introduced in the courts, was greeted with skepticism. And I think AI in many quarters is being greeted with skepticism too. But it may be that the ultimate connection in this third chapter around AI and the future of AI depends on standards to ensure that it's developed and used responsibly. So this chapter is still being written, and it's one that's going to be written in a quick way, but in a long way. It's one that we have to have a lot of open-ended questions, whether standards will be central to ensuring public acceptability and trust in AI, but also how AI will transform the standard setting and standard development process as well. How will it transform law as well too? Will we have no longer the need for generalized standards and generalized rules, but personalized ones? Will we have regulation by robot? These are open-ended questions, ones that are exciting, ones that we're living through, and ones that we're talking about today. So I'm delighted to be here with you for these conversations, and I urge everyone to stay tuned. This will not be by any means the last keynote address on technology, standards, and the law, and how they're interacting in the years to come. Thank you very much.
Thank you so very much, Professor Colanesi, for providing us with those enlightening and thought-provoking insights on the relationship and indeed the mathematical relationship between technology standards and law. Now it's my pleasure to introduce the moderator for our first panel, Kevin Fee. Kevin is a partner at DLA Piper, where he focuses on high-stakes IP litigation before trial and appellate courts throughout the country. Kevin's practice focuses on trademark, copyright, false advertising, and trade secret litigation. He also has substantial experience litigating patent and defamation claims. He has represented financial institutions, medical device and pharmaceutical companies, consumer products manufacturers, retailers, internet companies, and food and beverage companies throughout his trademark and false advertising practice. Kevin also represents major publishers, standards developing organizations, financial institutions, insurance companies, and software developers in copyright litigation. Please join me in welcoming Kevin Fee.
Thank you, Patty. First of all, let me say how excited I am to be talking to all of you today, and we have a great panel here. We thought maybe I'd kick it off with just some background and bringing us up to speed on where we are at the moment, and then we'll hear from all of our panelists about what this means and what their plans are going forward. So I'm supposed to have a clicker somewhere. Somebody have a clicker? Anyone? Next slide. Here we go. See if that works. Oh. Let's go backwards. All right, first of all, we can't have a discussion about copyright in IBR without first making sure we're all talking about the same thing. So what is a copyright? I'm sure many of you know, but a copyright is a type of intellectual property protection that is available for original works of authorship once they're fixed in a tangible medium. And a copyright, among other things, gives you the exclusive right to redistribute or republish the works. Next question, what is incorporation by reference? I'm sure many of you, if not all of you, are familiar with that. But generally, incorporation by reference occurs when a government entity references a privately authored standard as extrinsic material when drafting a statute or regulation, rather than writing or creating its own set of rules. Why do governments incorporate by reference? IBR saves the government and, in turn, the taxpayers a lot of money and time by limiting the administrative burden and creating their own government works. Plus, the government frequently doesn't have the expertise to do that as well, which is where all of the organizations that are members of ANSI jump in. It's also helpful to do incorporation by reference because it limits the burden on compliance for the parties that are being so regulated, because they're frequently already using those standards as best practices in their own businesses. So I thought it might be helpful just to put up one example of what incorporation by reference looks like, and that's what we have on this slide here. This is a regulation that addresses the Veterans Affairs requirements for veteran cemeteries. And as you see, it incorporates by reference the NFPA 101, which is the Life Safety Code. The one thing I want to sort of point out here, because I think it may come up later in our discussions, is you'll see it incorporates the Life Safety Code without any limitations on the scope of what portions of the Life Safety Code are being adopted. And you might wonder why that would matter, but here we're talking about an incorporation by reference with respect to cemeteries. But the Life Safety Code is much broader than that. It includes regulations, for example, for daycare facilities. And I think one of the issues that we're going to be struggling with going forward is, should those daycare facility portions of the Life Safety Code be impacted by incorporation by reference when the organization who incorporates the work by reference is only interested in the cemetery requirements? So what's the problem? Why is there an issue with respect to copyright and incorporation by reference? There are really two issues, primary issues at stake here. Obviously the standards development organizations need to have the incentives and the ability to fund the creation and updating of standards in a manner that will enable broad participation from a wide variety of interests. But on the other hand, once they're incorporated by reference, there is an interest in the public to have access to legally binding text. So courts have addressed these issues in at least two ways. One is called the Government Edicts Doctrine, which we're going to talk about, and another is copyright fair use. I'll just add a footnote here as well that courts are also sometimes addressing these issues under something called copyright merger doctrine, which, given our time constraints today, I'm not planning on getting into unless the questions lead us down that path. So we'll start with a little bit of a history lesson on how courts have handled these issues. In the 1990s, both the Second Circuit and the Ninth Circuit were forced to address the issue of what happens to works that were privately authored once they're adopted by reference into a regulation. And in the 90s, both the Second Circuit and the Ninth Circuit found that works did not lose their copyright protection merely because they were incorporated by reference. And courts frequently recognize that there is a real need for standards development organizations and other authors to have the copyright incentive in order to incentivize the continued creation of standards and other works. Then came the famous, or depending on your viewpoint, the infamous decision of Vec versus SBCCI in 2002. In that case, the Fifth Circuit Court of Appeals, in a 9-6 decision of the entire court, addressed the issue of what happens to a copyrighted works once they're incorporated by reference. And the Fifth Circuit held that when Mr. Vec copied the laws of Anna in Savoy, Texas, which he obtained from an SBCCI publication, and reprinted the quote-unquote law of the municipalities, he did not infringe the copyrights of the model building codes. Now, throwing the standards organizations at least a bone here, the court still continued to recognize that by writing and publishing the standards, SBCCI did own a copyrightable interest in the works. The court, however, reached a different conclusion than the Second Circuit and the Ninth Circuit did in the previous cases addressing incorporation by reference. And the way it distinguished those cases was it drew a line between what it described as extrinsic standards, which required citizens to consult or use a copyrighted work in the process of fulfilling their obligations, and the wholesale adoption of a model code, which it claimed was in front of them in that case. And the Fifth Circuit concluded that an extrinsic standard would not lose its copyright protections, such as the cases that were in front of the Second and Ninth Circuit, but a model building code that was written solely for the purpose of becoming incorporated into law did lose the ability to stop others from copying it once it was incorporated by reference. So there was at least arguably a split between the courts on how to handle incorporation by reference. And many were hoping that there might be some clarity provided by the United States Supreme Court when it decided to hear the case of Georgia versus Public Resource in 2020. Now, that case didn't actually involve incorporation by reference, but publicresource.org in its cert petition did ask the court to hold that, let me get the quote here. It asked the court to hold that, here we go, works that represent an authentic exercise of state legal authority, including legal works adopted by or published under the authority of the state, are uncopyrightable edicts of government and not the proper subject of copyright protection. Now, the Supreme Court didn't actually go ahead and take on such a broad question. It concluded that the question before it in that case was whether or not copyright protection extends to annotations that were contained in Georgia's official annotated code. And the court held that it did not. It held that the government edicts doctrine, which it holds that officials empowered to speak with the force of law cannot be the authors of, and therefore cannot copyright works that they create while in the scope of their official duties. And the court drew a clear distinction and rejected the argument of some that the government edicts doctrine turned on whether or not the language had the force of law. The court said that the government edicts doctrine is a straightforward rule based on the identity of the author and not on whether the given materials carry the force of law. The important point for our purposes here is that the Supreme Court made clear that, if you see in this last bullet point, the government edicts rule applies to binding works such as opinions and to non-binding works. It does not apply, however, to works created by government officials or, for our purposes here, most importantly, private parties who lack the authority to make or interpret the law. So under the Georgia versus Public Resource case, I think it's pretty clear that the government edicts doctrine doesn't apply to standards that are privately authored. Unfortunately for standards development organizations, perhaps, the government edict doctrine is not the only argument that's been used to try to defeat enforcement of copyrights by standards development organizations. There's also fair use. And that brings us to the recent case of ASTM versus Public Resource that was just decided in the last month by the DC Circuit. In that case, the court held that non-commercial dissemination of the standards at issue there that were incorporated by reference in the law was constituted fair use. And it did so by walking through the standard for fair use factors in the Copyright Act, which we're going to walk through quickly here. The first fair use factor, for those who aren't familiar, is the purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. Now, the court found that public resources use was non-commercial. I will note that that was a subject of dispute for sure during this matter. It is true Public Resource was a not-for-profit entity, but they were sometimes using the promise of reproducing standards in their fundraising. Nevertheless, the DC Circuit concluded the use was not commercial. It is, I think, again, worth pointing out, as this will probably come up during our discussions, that even the DC Circuit recognized that there might be a different result if a for-profit firm starts charging customers for copies of standards that are incorporated by reference. Another important part of the DC Circuit's finding was that public resources use was transformative because it serves a different purpose than the plaintiff's works. Now, you may be asking yourself, how does the fact that public resource makes the exact same works available online as the standards development organizations were doing transformative in any way? The way that the DC Circuit concluded that it did is it said that public resources message is that this is the law, and that is different from the standard development organization's message, which was that the current practices for the engineering of buildings and products are X, Y, or Z. Now, that analysis just completely ignored the standard development organization's reading rooms, many of which were put in place specifically to make available what was now binding legal obligations once they were incorporated by reference. And unfortunately, there wasn't a great deal of discussion about why those reading rooms were ignored. But in one sentence, the DC Circuit does say that it's not focusing on that issue because all but one of the rooms was open only after Public Resource started publishing the works online for free, and because Public Resource allowed printing and searching of its reading room. Now, that wasn't certainly satisfactory to me, I will say. First of all, what about the standards development organization that did have this room available before Public Resource posted the things online? Maybe the answer is, well, look at our second explanation as for why we're ignoring that reading room, and that is because Public Resource allows printing and searching of its reading room materials. The only problem with that, well, I shouldn't say the only problem, one big problem with that is, as you see the heading of this slide, is ASTM versus Public Resource 2. There was an earlier DC Circuit decision in litigation between these parties where the court made clear that just making changes in format to improve accessibility would not constitute a transformative use. So I think that the DC Circuit's recent decision is pretty inconsistent with what it had said just a few years earlier in this case. The second factor for fair use is the nature of the copyrighted work, and I'll run through this pretty quickly because we're running short on time. But what the court concluded is that standards, especially once they're incorporated by reference, are on the outside edge of copyright's protective purposes. The third fair use factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. Now, ordinarily, you'd think because they copied everything that was posted or authored by the Standards Development Organization, this factor might favor the Standards Development Organizations. But what the DC Circuit concluded was that because the entire work was incorporated by reference, it was reasonable for Public Resource to publish the entire work in its and that this factor also favored a finding of fair use. The final fair use factor has to do with the effect of the use on the marketplace. And here, the DC Circuit concluded that the fourth fair use factor does not significantly tip the balance one way or the other. It acknowledges, I think it had to, that common sense suggests that once you make something available online for free, you're going to decrease the market for people who are going to pay for that. But it sort of discounted that because it concluded that the record evidence did not strongly support such a finding. And then it also concluded that the public benefits associated with posting these online in yet another area outweighed or at least counterbalanced some of that downside to the marketplace. Now, this finding in particular is, I think, a little frustrating for me as well, personally. The Supreme Court has said that this factor is the most important factor in analyzing fair use. And you would think that if there's, it doesn't really tip one way or the other, it's a little hard to imagine why the DC Circuit concluded that summary judgment was appropriate in favor of fair use here. You would have thought at a minimum there would be some sort of trial to determine whether or not the most important factor favored one side or the other before reaching any final conclusions. So this is far from the final word on the impact of incorporation by reference on copyright. You see there's a handful of other cases that either were recently decided or are still pending. Many of these involve an organization or organizations that are posting the standards online that are for-profit entities as opposed to publicresource.com. One other one I want to just flag, which I think is interesting, is the Canadian Standards Association case. There is an oral argument in the Fifth Circuit again, which is where the Beck case came from, just last week in this case. And what it addresses is what happens to copyright protection for standards that were incorporated by law in Canada, and what is the impact of that on the US copyrights. It's certainly possible that the Fifth Circuit will deal with that without addressing issues that we're talking about here by saying it's a different ball of wax if you're incorporating laws in Canada than if you are in the United States. But it also may chime in and give us some more insight on what VEC means, especially in light of the Georgia case by the Supreme Court. And finally, I'll just note at the bottom here, there's also the Pro Codes Act, which I'm assuming many of you are familiar with, and I think we'll be hearing more about that from our panelists. So finally, where do things stand right now? The standards development organizations in the ASTM case still have the option of seeking Supreme Court review of the DC Circuit's ASTM case. They haven't made any filings to that effect yet. And as I've alluded to a couple times, I think it's pretty clearly at least tension between the holdings of the DC Circuit and the Fifth Circuit, which have refused to enforce copyrights after incorporation by reference, and the Second and Ninth Circuits, which reached separate conclusions. I also alluded to several cases against a for-profit entity. That entity is UpCodes. Those cases are continuing to be litigated, and they're being litigated in jurisdictions that have had more favorable decisions for standards development organizations with respect to copyright. The CCC case and the practice management case in the Second and Ninth Circuits, respectively. And even the ASTM 2 decision from the DC Circuit suggests that commercial use by organizations of IBR standards may not fare as well in the fair use analysis. And as I've alluded to, there is also the possibility of legislation on this front. So now that we have that all teed up, I want to start to introduce our panelists and get their input on what's next and what they're doing in light of these recent changes. First, I'm going to introduce Stephanie Renish. Stephanie is the Director of Technology at American Society of Heating, Refrigeration, and Air Conditioning Engineers, or ASHRAE, where she has worked since 2003. At ASHRAE, she oversees the development of over 100 consensus standards and guidelines, provides procedural and policy direction to committees responsible for developing all ASHRAE standards, guidelines, and addenda, and advises executive officers on standards-related activities. Stephanie also oversees ASHRAE's involvement in the ISO community, technical services, and research activities. So with that, take it away, Stephanie.
Thank you very much. I'm so honored to be here today. I'm speaking amongst this wonderful group of panelists, and I'm sure I'm going to learn more than what I give to you from the panelists and questions and answers as we move forward. I'm here to talk about the SDO's perspective on the recent decision in the ASTM case. As many of you are looking at, we have challenges given the new decision on what we're going to do related to IBR standards. Obviously, one of the biggest challenge that we see is finding a way to make up for the loss of standard sales as a result of this decision. As I'm sure is true for other STOs as it is for us, the revenue from the sales of standards is a significant revenue stream. And so how do we address that without decreasing support for the development of standards and slow down the process when we are living in a time when we're asked to deliver standards faster? Second is going to be policing for the commercial use now of our IBR standards, and this could be an added challenge as well. What all is a commercial use that we're going to have to watch for? Is advertising on that page going to be a reason to say they can't use it beyond just the sale of standards? I think that's going to be a gray area moving forward. Third is really stepping back and looking at what standards should be referenced in the code, and do we advocate for IBR or just portions of our standards instead of the whole document? And if we do that, how might that affect other actions related to standards, such as recruiting volunteers to participate in the development of our standards? We have thousands of members and non-members of ASHRAE that participate in the development of over 100 standards at any given time. And then the advocacy efforts as well. Then it looks at, do we need a new business model for standards development, and what should that be? So we've started at ASHRAE trying to look first mostly at the revenue side of things, I think, which is always a concern. So we haven't come up with the answer yet, and we're still throwing things at the wall to kind of figure out how to move forward. And so while I have a list of things we've talked about, they're not final, and I'm sure I'm going to hear from things today from the panelists and in the room of other ideas that I can take back. So our first focus has been on, obviously, the funding. So we've looked at developing new derivative products and what that might look like. Would we instead put our efforts on developing supplemental guides, more training materials, certification programs, tools for standards implementation? Do we move all of our informative appendices out of every standard and sell those separate, which often gives some guidance to the users? Could we charge fees to participate in the standards development process, and what would that look like? It could affect our balance. It could affect other issues related to that. Should our members pay higher fees to offset that loss in revenue? While our standards development process doesn't require membership in ASHRAE, we do have members, and those fees obviously do help offset costs. Do we increase those to do that? Could we better promote the availability of our read-only pages of our standards, where we can explain this is the true standard and code? It's not copied and scanned in, and you're not going to find errors, because I envision there will be some liabilities to people if they use something it's not the exact language or requirements. And our readers have greatly improved in quality. It's faster. I think I started 20 years ago, and a turtle could walk across the stage faster than the page would turn on the reader. But now it's fast, and you can search it. But do we look at other ways to get money? Obtain sponsorship for standards development. What would that look like? And would that tarnish the process of balance, openness, and lack of dominance if we went that route? Or are there other grant opportunities that we could look into? Of course, revenue is important, but we're trying to think of other ways to do that. And Kevin mentioned this, and that's through the Pro Codes Act. This is a current proposal that's supported by NFPA, ICC, IAPMO, UL, and ASHRAE, that would protect the copyright and the integrity of the process. It would allow for the free viewing on publicly accessible sites to meet the law and still keep the copyright. It would protect our process and protect standards developing organization. And the best thing, it wouldn't cost anything to taxpayers, which to me, as a taxpayer, is a good thing. So I'm sure there's others, and I think also following the lawsuits is going to be important as well as things develop in the upcodes cases and others. So I'm actually excited to keep my time shorter so I can hear more things from everybody and maybe hear some more solutions today. Thank you.
Thank you, Stephanie. Let me now introduce Michael A. Lindsay, who is a partner at Dorsey & Whitney LLP, where he has practiced for over 30 years and serves as co-chair of the Antitrust Practice Group. His practice focuses on antitrust matters in litigation, mergers and acquisition transactions, and client counseling. And his broad litigation expertise includes antitrust, patents and trademarks, securities, product liability, insurance coverage, and general commercial litigation. He's advised standards development organizations, participants in SDOs, standards implementers, and essential patent holders. Michael also serves as the editorial chair of Antitrust Magazine and has taught antitrust as an adjunct professor at both the University of Minnesota Law School and the University of St. Thomas Law School. Take it away, Michael.
So I'm feeling like a bit of a talking copyright infringement myself today, because I'm going to be repeating some of what both Kevin and Stephanie said. But I think that, getting different perspectives on the same topics can be helpful. So we may be hearing even two more perspectives after this. So first, just the very recent ASTM case, which is obviously top of mind. Kevin has already mentioned, as did our keynote speaker, that it was issued a month ago today. The time for a petition for rehearing was 14 days later, and the ASTM side chose not to file that petition. That would have been to ask the appellate court to hear the case over by the same three-member panel or by the full court. You'll recall the Fifth Circuit decision that Kevin mentioned had the words en banc after it, which means the entire court, rather than a three-member panel of that court, made the decision. The deadline for a petition for writ of certiorari, that is to say U.S. Supreme Court review, is 90 days from September 12. I know that no petition has been filed yet. I don't know whether ASTM will be filing one. So what is the exact holding of that case? And Kevin did mention this, but I think it's worth coming back to. So the court's holding is very broad. We hold that the non-commercial dissemination of such standards as incorporated by reference into law constitutes fair use and thus cannot support liability for copyright infringement. So for any matters in which the deciding court is the DC Circuit Court of Appeals, and granted it's a small geographic area, but it's a much larger significance, any non-commercial publishing of a standard that has been incorporated into law constitutes fair use. That's a pretty broad holding. Kevin already talked about this, and I share his concern about whether the purpose and character of use is really is transformative, because it's basically repeating the same language for a slightly different purpose that isn't really transforming the work. It's simply porting it into a new location. The nature of the work, you can't deny that the standard, as shown in Kevin's example, was incorporated into law, but you also have to ask the question, how much of it did the incorporating body actually intend for people reading the law to follow, as opposed to its extra language? And it was just easier for us to say we're incorporating the whole standard rather than the part that we care about. And then the extent of use factor, I was actually reminded, this takes me way back to law school days, of the human cannonball case, where the issue was whether someone could publish a video that was only 5 seconds long of a guy being fired out of a cannon. Well, yes, it's only 5 seconds long, but that's the entire act. Once you see that, you don't need to go see the show live. But I do want to stop on the commercial republisher issue, because I think there's more to this than we've heard thus far. So the ASTM court did indeed acknowledge a distinction between commercial and non-commercial republishers. The commercial publisher is, of course, obviously trying to get a profit out of its activities in republishing the work. The non-commercial player theoretically is not doing so, although, as Kevin mentioned, if you're using it in your fundraising, you're using it really to support an activity, and nonprofit doesn't mean you don't make a profit. It means you can't distribute that profit to shareholders. You could still be making a profit, and that funds an organization, creates jobs for people, which may be a good thing, but it's, the distinction between commercial and non-commercial really is not as categorical as it should be. It also might not be dispositive because a few years ago in the Google v. Oracle case, the court said that finding that copying was not commercial tips the scales in favor of fair use, but the inverse is not necessarily true. So in other words, if you think of it as a balance, if it's a non-commercial use, that tips it. But if it's a commercial use, it might leave the balance just as it was. So standards organizations do need to be concerned that that distinction may not be as strong as the ASTM court suggested. Kevin and Stephanie have both mentioned the Pro Codes Act. And let me put the text up there because I think it's, when you're thinking about legislation, it's useful to focus on what is the exact language. So what this says is that if you have a copyright to begin with, and think back to our keynote speaker's comments that maybe an AI compilation of text will not create a copyright. So you do have to address that threshold question, do I have a valid copyright in my standard to begin with? Then, notwithstanding that it has been incorporated by reference, then if that standards organization, after obtaining actual or constructive notice of the incorporation by reference, makes all portions of the standards so incorporated publicly accessible online at no monetary cost. So in other words, the SDO, once it knows that there has been an IBR, makes the text available at no monetary cost. Now, what kinds of questions does that raise? Well, first, what is constructive notice? That's, the litigator in me loves that language because it creates room for litigation. The counselor in me would prefer to have a clearer answer. And you could ask the question, why is there no duty on the IBR government body to notify the STO? We have incorporated your text. How will the STO constructively know which portions have been incorporated? I mean, the STO could think, yeah, we are putting our standard out there, but what if in addition to incorporating the standard itself, the STO has moved some language into a different document, as Stephanie suggested, and the IBR government entity incorporates that too? How much and what kind of public access is sufficient? So if you have, and we can all agree that if you have a legal obligation, you ought to be able to determine what that legal obligation is. That doesn't mean it has to be absolutely the most convenient way to do that. After all, and I'm of course happy for this part of reality, sometimes people consult lawyers to figure out what statutes mean. I will, from time to time, offer my services for free, but let's say I have to make a living too. So how much public access is sufficient? What about that search and print function? Is that really a necessary aspect, or is that simply a convenience factor? So you have to think about whether the standards organization under this act would be required to provide that. Can the STO require the user to create an account and provide contact information? The draft bill says yes. I think that's put into the definition, so that should say that the no monetary cost language doesn't mean you can't collect that information. But it also doesn't, the draft bill doesn't say what you are permitted to do with that information. And if you use that information, say, to send out follow-up emails to people, you liked this code, try looking at this other one as well, does that constitute a use that might be converted into a form of monetary cost? So Stephanie has already commented on some models. We thought independently about these, and I came up with several of them, financing through participation fees. A lot of standards organizations, particularly if the text is not going to be incorporated by reference into law, do charge these fees. And there's nothing inherently wrong with that, but Stephanie is correct that if you charge for something that was previously free, you are going to affect the incentives for participation. And that's something that a standards organization needs to think about. The concept of content shifting. So you narrow what is said in the standard and move the rest of it into a guide. The problem is, first of all, does your standard really still meet the test to be a standard? How much content can you move? You can't have a standard that says, do the right thing and put everything else into the guide. That obviously doesn't work. So it creates that issue. It also creates additional work. Someone's going to have to figure out, okay, if we can know what that test is, how much language can we move over and which is the language we should move over? And then the other idea, and I will admit this one is less practical and less likely to work, charging a license fee for the right to incorporate by reference. I have no idea whether that would actually work, but as we're spitballing ideas here, it's one I wanted to put out for discussion. Oops.
Great. Thank you, Michael. Let me now introduce Elise Owen, who is the standards executive at the United States Environmental Protection Agency. She facilitates implementation of the National Technology Transfer and Advancement Act, or NTTAA. She has an extensive background in facilitation of standardization activities in both the public and private sectors. She most recently served as Associate Vice President, Global Strategy and Analysis at the Advanced Medical Technology Association, or AdvaMed. In this role, she oversaw AdvaMed's activities in China with the objectives of increasing opportunities for the medical technology industry in China while supporting the country's long-term health and development goals. Prior to AdvaMed, Elise was Director of International Development at ANSI, working on expanding the Institute's engagement internationally. Take it away, Elise.
Thanks so much. It's great to be here. I'm just going to speak, no slides today, but I'll start by telling you all a little bit about EPA, talk about how we use and participate in standards at the agency, why we use and participate in standards at the agency, and then talk a little bit about what it means kind of from an agency's perspective to IBR. I think that's helpful context for this discussion. So starting about EPA, our mission is to protect human health and the environment. We are, I'd say in the scheme of things, kind of maybe a medium-sized agency. Our FY23 enacted budget was a little bit over $10 billion. Our workforce was a little over 15,000. We are growing quite a bit with recent legislation like the Inflation Reduction Act and bipartisan infrastructure law. When folks think of EPA, I think a lot of times you think of a regulator, and that's why we're here today, is we're talking about things in a regulatory context. It is important to kind of note that we do have a pretty broad portfolio of work beyond developing and enforcing regulations. We also give grants. I think somewhere around half of our budget goes out to grants. We study environmental issues and research. We sponsor partnerships. So some well-known partnership programs in the standards community are things like Energy Star and WaterSense that are non-regulatory programs. We teach people about the environment, and we publish information and disseminate information about environmental protection. And I'll say that standards are an important part of our work across all of those activities, not just our regulation, but I will focus on our regulation today. So next, talking about standards at EPA, we are a pretty solid agency, both in our participation in standards as well as our use of standards. At last count, we have over 150 staff that sit on standards development technical committees. We sit on ASHRAE. About 50 of our staff sit on ASTM committees, and there's probably 30 to 40 other standards bodies that we sit on their committees. There's actually a list on our website of everywhere that we participate, and we update that annually. When it comes to regulations, we have over 4,500 IBR references to private sector standards in our CFR, in our Code of Federal Regulations. So there's a lot happening, and I would say we're seeing more and more coming every day. We also, incidentally, beyond our participation and use of standards at the technical level, we sit on governance committees. So we sit on the board of directors of the American National Standards Institute. I represent EPA there, as well as chairing the government member forum. We also sit on the board of directors of ASTM. And so next we'll talk about why. Why do we do this? I think Dr. Coglianese, did I say that right? He talked about the National Technology Transfer and Advancement Act and kind of, legal reasons that we use standards as an agency. And those are very important. They're also underpinned by OMB Circular A119. And I should say, like, beyond the legal and regulatory reasons that we use standards, we also do it because it's good for the country in general. When we get it right, when we use standards, when we base our requirements on standards, there's an opportunity to advance our mission in a more effective way, and also to serve our stakeholders better and serve the country better. And so that's really what it's all about. I often say I have a soft spot for standards. I've been in this community for 20 years, but we don't do it for standards' sake. We do it because it's an opportunity to advance our mission and to help our stakeholders. It's pretty widely acknowledged that use of standards and regulation, as well as voluntary programs and other activities, can be an effective way to achieve robust engagement with industry, academia, non-government organizations, and others. So it's a way to have a really broad reach and get a lot of perspectives to take into account. It also helps harness partnerships that establish trust with the public, and that can lead to durable policies that last. And I think somebody mentioned enforceability. When we're building requirements based on things that are already industry practice, that can really help advance enforcement and compliance to regulations. Using standards as a basis of our regulation can help us comply with international trade laws. And there's a number of other reasons why it's beneficial to our mission, and it can be beneficial to our stakeholders. We do have a website. It's epa.gov/VCS, Victor, Charlie, Sierra, like voluntary consensus standards. And that has a lot of other case studies that kind of talk about beneficial examples of us using standards. When we talk about IBR specifically, I think in this discussion, we kind of drop that casually and say, oh, it's an IBR, that happens. And I kind of wanted to weigh in and talk about the fact that it is a fairly complicated operation to incorporate a standard by reference into a rule. It can take months. It can take a lot of people focusing on that and working together to make that happen. When we do incorporate standards by reference, several laws come into play, and I think that's already been talked about. There's the Administrative Procedure Act, there's FOIA, there's copyright, there's the National Technology Transfer and Advancement Act. And so as agencies, we kind of have to comply with all of those different laws, guidance, and other things at the same time, which can be incredibly complicated. I think it speaks to why it's so important, the fact that people do make that effort to make that happen over and over and over again. That speaks to the benefit of the practice of using standards and the opportunity that brings. I also say, when you're trying to navigate all of these procedures, it really does take a village. So it's not something that one person decides, and there it is, it happens, there's an IBR in our regulation. Within EPA, we have several offices that work together when we want to do an incorporation by reference. I actually have a couple of colleagues here I'll introduce. So Karin Weller Layla. And then my boss is Michael Hardy over here. So if you guys don't know these folks, go introduce yourself. They're awesome. But these are a couple of the folks that we work with when we try to navigate these IPR processes, and there's quite a few others inside of EPA. Within the federal government, we work closely with OMB, with NIST, with NARA, and you'll hear from Miriam next. And we really take guidance and leadership from those agencies and how we should be doing that, and then work within our own agency to figure out how to implement and operationalize. And then finally, we collaborate very closely with private sector standards bodies who are the copyright holders of standards. And without that collaboration, it's hard to imagine how an IBR would happen. It starts with standards bodies will often contact us and give us information about standards that might support our regulatory objectives. So we publish our regulatory agenda every 6 months. We let the public know what we're thinking about doing. And a lot of standards bodies will contact us and say, hey, you want to do X, Y, and Z, here's a standard you might want to think about using. And that's such valuable input to us. We also do our own analysis, of course, but hearing from the experts is incredibly valuable. And then when we need to kind of look at a standard and figure out, should we use it or not, we often contact standards bodies in this room to ask for evaluation copies of standards so that we can look it over and see, is it suitable for IBR? Is it something we should be using? We'll often reach out to standards bodies and ask for technical exchange with their committee to kind of understand how did this standard come to be and why is it written this way? And having that deeper understanding helps us, I think, know if we should use it, how we should use it. These are important questions. And then, once we do decide to IBR, we do a public comment and work with a standards body to get, a copy of that into a reading room during the public comment period. And then once the regulation is finalized, getting that finally into a public reading room for an IBR. So there's so much collaboration and so much kind of hand-in-hand action that makes this work. And so as far as, what if question here, what do the cases mean so far? What might future legislation mean or future court decisions? I think for 20 years or more, I've been hearing from stakeholders in the government and the private sector that, it's a good idea for agencies to use standards. Of course, it's supported by law, but beyond that, it's just good business to consider that. Strong collaboration is needed to make that happen. And I think the recent court cases and kind of the uncertainty of what's to come, could potentially jeopardize that or make it harder. It could, mean that we have to work more to make an IBR happen than we already do, which could pull resources away from other important work. So, we're grateful to be here, excited to hear ideas and discussion, like Stephanie said, learn from others, and maybe walk out with some solutions that can make this all a little bit easier for all of us. So thanks again for having us.
Thanks, Elise. Next up is Miriam Vincent, who is currently the Acting Director of Legal Affairs and Policy at the Office of Federal Register. Miriam has 25 years of federal service and has been a lawyer for 26 years. She started her career working with victims of domestic violence in Appalachia and spent 9 years with the Office of Disability Adjudication and Review, which is part of the Social Security Administration. The rest of her federal career has been spent as a paralegal while a law student at Georgetown, staff attorney, and in her current position, totaling nearly 16 years of service. Miriam has recently rewritten the Incorporation by Reference Handbook. She attended Pacific University in Forest Grove, Oregon, studying abroad in Japan and France. Thanks for being here, Miriam.
Thank you. I'm happy to be here. My other option was to be testifying in a different state. So luckily that didn't happen and I'm here today. I'm very pleased with that outcome. So I just have this one very basic slide. I'm going to start off our role in incorporation by reference. The Office of the Federal Register, we publish the Daily Federal Register and the CFR, as I'm sure all of you know. We are form over function, if you will. We are agnostic on the use of standards. We are agnostic on what you put in, what agencies put in the regulations. We focus on formatting, on codification structure, on enforcing a normalized standard across agencies, across documents, across regulations, so that, except for 26 CFR, which is the IRS tax code, basically any CFR volume you go to, you're going to get the same section numbering, the same part numbering, the same paragraph structure, so it's not unique to any agency. We have no idea what the regulations are, what they mean, how to follow them. We don't actually read for that. So yeah, our role is, we can tell the agency how to do it, if that's what they've decided to do. We can't say whether to do it, and we can't say what to use, because we have no idea. Our staff is right now about 50 people, and we service over 300 agencies. We publish between 26 and 32,000 documents a year, and a good portion of those are final rules that then require additional work to go into the CFR. So that's it. We cannot advise on how to implement the NTTAA or how OMB Circular A119 impacts a particular agency. We don't know. Despite, many members of the public thinking otherwise. But under the FOIA, since 1966, when Congress looked at all the regulations and said, we should probably organize these and have some sort of structure and ability to track all of the stuff that has been incorporated before 1966, Congress decided to put the process in the hands of the Office of the Federal Register. So it's the director of the Federal Register, not the archivist, which is his boss, and not the Administrative Committee of the Federal Register, which is the archivist, a member of the Attorney General's staff, and the used to be the public printer. GPO has changed their name, so it's now the director of the Government Publishing Office. The Administrative Committee of the Federal Register is what establishes the regulations and the operations of publishing the Federal Register and the CFR, but not IBR. Congress did not give that authority to the ACFR. Congress gave that authority solely to the director of the Federal Register. So we have regulations. We've recently reissued the handbook. We're converting that into an online platform. So again, Carrie, that's another intersection of technology and the law. But we then, because of the statute and the regulations, have a process for how agencies can incorporate things by reference. There have been only a very few cases where the IBR process itself was in question. And similarly, there was a 1978 case, and I did not look it up, I should have, against EPA, unfortunately, where EPA bypassed the IBR process and just put the reference into the regs. And EPA's argument was, well, but it would have been approved. And the court's conclusion was, yeah, but you didn't actually get approval. So you get to start again and make sure you dot your I's and cross your T's, because you cannot enforce the material if you haven't gone through the process. we did a rulemaking 2012 to 2014 where we changed a good portion of the IBR regulations. Part of that was prompted by publicinterest.org as filing a petition, a joint petition with a number of other individuals. And one of the requests that the petition made was that we, the Office of the Federal Register, redefine reasonable availability as meaning only free and online. And we declined to do that because we can't force agencies to violate copyright. We can't force standards to change their business model. And if we implemented that new definition, we would, in a sense, be telling the agencies, you can't regulate this way, you have to change your regulatory process. And that is not our function at all. So one of the ways that we have floated, although not publicly, this will be the first public suggestion of this idea, for agencies to limit what they are incorporating if they only need to incorporate a piece of something. Because either the agency can say, I want to incorporate this section. And if it's a defined section, and they can actually take just that section out of what they have and put the front matter of the standard on there, we will allow incorporation of just that standard. But sometimes the agency can't do that, or there is no defined piece that can be specifically referenced. So one possibility, if agencies can work with the individual SDOs, is that the SDO produce just an abbreviated portion of that standard with the piece that the agency needs to incorporate by reference. And that then can be described and given to the Office of the Federal Register, because we have to have that copy, because the material is deemed published in the Federal Register. And in order to complete the Federal Register issue for any given day, we have to have the material that is deemed published, as well as what is actually published, and that gets archived as a permanent federal record. So we have to have that PDF file, or the image file, or the other electronic file. It can't be that you're relying on online access, because when we go to incorporate that or archive that 15 years from now, we don't have it. We don't own it. We can't put it in the archives. But if it's a possibility for the agencies to work with the SDOs to produce just that snippet, that's something that we would take. We are always happy to work with the agencies and in conjunction with the agencies and the SDOs to try and work something out on a case-by-case basis. Although we typically do not have any direct involvement with the SDOs, because that's one step beyond what we normally do. And as I was sitting here, sort of listening to all of the panelists and the discussion, I have half an idea about another alternative that might work regarding how we structure and define the regulations for the incorporation by reference approval itself. But as I've just come up with it, I can't say that that's really going to work, and I haven't fleshed it all out. But I mean, but in light of the decision, our process is not going to change because the decision did not actually impact the FOIA provisions or our regulations. And we foresee that there may be difficulties that agencies are going to run into with this. And so what we said and what we will continue to say is that until there is something else out there, we will work with the agencies on a case-by-case basis to see if there's some way around this that works for us, for the agency, and for the SDO itself. And Michael, I just want to say one thing about constructive notice. Under the Federal Register Act, anything that's published in the Federal Register provides constructive notice. So if nothing else, the SDOs would have constructive notice when the Federal Register came out. I don't know how helpful that would actually be to the SDOs, but that is one definition of constructive notice.
That's definitely helpful from the federal perspective, but what about the thousands of municipalities that are adopting building codes?
Exactly, right. And since we only publish on behalf of the federal government, none of those would actually appear in the Federal Register to provide that notice. So thank you very much.
Thank you, Miriam. Our last panelist is Roy Kaufman. He'll be joining us remotely, so hopefully he'll be up on the screen in a second. Roy is the Managing Director of both Business Development and Government Relations for the Copyright Clearance Center, or CCC. Previously, he served as Legal Director at John Wiley & Sons, Inc. He is a member of the Bar of the State of New York, the Authors Guild, and the editorial board of UKSG Insights. Roy advises the U.S. government on international trade matters through his membership in the International Trade Advisory Committee 13 on intellectual property and the Library of Congress's Copyright Public Modernization Committee. He also serves on the Executive Committee of the United States Intellectual Property Alliance Board and has written and lectured extensively on copyright, licensing, open access, AI, metadata, text and data mining, new media, artist rights, and art law. Roy also is the editor-in-chief of Art Law Handbook from Antiquities to the Internet, and the author of 2 books on publishing contract law. Take it away, Roy.
Hi, thank you. Hopefully everyone can see me. Thank you so much for inviting me to this. Sorry I couldn't be there in person, but I'm preparing for a trip to Frankfurt, including a conversation with Boyd Din to talk about AI and standards. I also just want to mention briefly that my presence here has been partially underwritten by the Department of Commerce, who's given us a grant to provide copyright education around standards. Next slide, please. So for those of you who know CCC, we're best known as the collective management organization for text in the United States, although our corporate licensing is global, and text, of course, includes standards, which is why I know something about standards. I think of myself more as a copyright person who knows about standards, and I'm following a bunch of standards people who know quite a bit about copyright. Good and bad about batting cleanup is that I'm trying to figure out what hasn't been said and rewrite my script to say something slightly different or innovative. Let's go to the next slide. So, CCC, as seen on the prior slide, we're in a lot of different spaces with respect to standards, everything from metadata and tagging to enrichment, but I'm really going to focus here on 2 core businesses: collective licensing and what we're calling right find, that's really document delivery. Next slide, please. So collective licensing, that's generally blanket licensing. A corporation, in this case, pays us a fee. Let's go to the next slide, actually. Pays us a fee to be able to use lawfully acquired content, reuse and share for internal purposes. And that content, if it's used and it's a standard, we pick up that usage, we pay royalties. And this is all sort of under the Texaco case, which held that kind of corporate reuse requires permission of the rights holder. And on the left, I apologize if you're an SDO who participates and your name isn't there on that list. There's quite frankly, quite a bunch more, but we can fit them all. Let's go to the next slide. Standards in RightFind. So RightFind is a research platform that we license. So a lot of our licensees don't have RightFind, but if you're a research intensive organization, you might be using RightFind. Let's go to the next slide. And what RightFind does is it allows the researchers to find content. It knows if they have an institutional subscription to that content. It knows if they don't. It has document delivery capabilities. So if there's a standard, an SDO is participating with this, and someone discovers a standard, we can deliver that standard to them, that user immediately at the publisher set price. Again, this will be relevant to the next conversation. So let's go to the next slide. Everyone's talked about this case, so I'm just going to focus on a couple things that weren't said. Okay, first of all, the district court case, not all standards are, are fair use to put online. The standards here that were subject to appeal were only ones that were IPR. I think it's just important to remember that. So there is copyright protection in standards, and fair use did not extend, no matter what the other factors said, to the works that were in IPR in this case. There's been a lot of talk about whether public resource is nonprofit educational. That was the court's finding. I think it would be interesting for people to look at another case, which is the Internet Archive case. And in the Internet Archive case, didn't involve standards, involved books that were made available online and by an organization whose nonprofit mission status, everything else was actually quite similar to public resources. There's differences too. And there, the fact that it was nonprofit didn't change the balance to fair use. And so just remember, just because it's nonprofit doesn't mean it's fair use. Just because it's for profit doesn't mean it isn't fair use. I thought as a copyright lawyer, this discussion of transformative use was weird. It's the only word I have for it. Looking at two mission statements and saying, well, the work is transformative because the mission statements are different, that's just strange. I looked at my my former employer's mission statement, which I have there. And if you want to look at the Internet Archive's mission statement, it's to make universal access to knowledge. Well, okay, that's not the same mission. That doesn't make it transformative. You don't, by the way, need to be transformative to find fair use. And as a copyright lawyer, transformative is a strange thing because it only appears once in the statute, and that's in the exclusive right to make a derivative work. I'm going to keep moving really quickly. Let's go to the next slide. There's been talk about, nature of the work. It was factual. I think that's a pretty true statement. Amount of the work, I thought the court's analysis here was also kind of weird. Normally, you're talking about how much of the work was copied. Was it a little bit? Was it the whole work? And even when the whole work is copied, that's more likely, this is the third factor, more likely to find for infringement, non-fair use infringement. However, if the court wants to find fair use, they'll say, well, this is neutral because you had to incorporate the whole standard. And that's what I would have expected the court to say. The fact that this language, it was just weird. I don't understand. That's just not the copyright standard. Market harm, yeah, this is the fourth factor. This is what you really need to spend more time on. The court said, common sense suggests that free online access to many of standards would tamp down demand. Yes, that is a true statement. It's not just common sense. It does and will happen. So why don't we go to the next slide? A lot of these things have been kind of covered, but just, again, what are the consequences when the bargain is broken? And all of the things we're talking about, they're a little bit disturbing. What's the bargain? The bargain is we have voluntary non-governmental standards that are created by huge committees of people that we want to have incorporated by reference because they're good. And now you've created this tension between economic sustainability and viability of the authors, the SDOs, and their utility on a mission base. And we need to figure out how we're going to resolve this because we need great standards, and that's too important to pass up. And we need sustainability. So So what are the consequences? In discussion of the upcodes, if it's commercial, non-commercial, you're licensing in, let's say, you're a database and you're making available statutes, but you also want to have the standards. Now they're incorporated by reference. I'm not saying where the answer is, it muddies the water. Certainly, if there is a different decision, there wouldn't be an argument here on that commercial use. Something else I want to talk about, exception washing. So what does that mean? I'm going to give you a very concrete example. I'm just going to blow through this. Under EU law, if you want to retain your commercial rights for text and data mining, which is fundamental part of AI training, you need to explicitly reserve those rights in your online content. That's great if you control your online content, but if your online content is controlled by someone who you sued, who doesn't like you, and who's been given a copyright exception, how does the commercial user in the EU know that you've reserved your rights when they're going to go to PRO and take this? Now, commercial licensing is intact. So what do I mean? The CCC collective licensing, I mentioned the Texaco case. That's still there. That's good. I don't think that's going away. Texaco has not gone away yet. However, I work in science publishing more than I work in standards. We have something called open access. And there, what we've discovered, not shockingly, is when material is available for free online, even if it's a non-commercial license, it removes the incentive to purchase documents, and there are less documents purchased. Let's go to the next slide. A lot of these things have been discussed, so I don't know if there's going to be appeal. I'm not the lawyer here. There's the Pro Codes Act. It's interesting. I wasn't the only one who came up with charge governments either through grants or charging them to incorporate by reference. I mentioned scientific publishing. This open access model basically flipped who pays. So it used to be the libraries paid for subscriptions to content. Now the authors and creators pay. It's a totally different model from what I'm saying here, but you sometimes do just have to flip who's paying. Do we avoid incorporation? That would be a terrible result from this case. Absolutely terrible result. But we've had all these conversations. Well, incorporate this, but not that. Put this somewhere else. You have to consider it. It's the right thing to do. You need to be sustainable to create standards. But so these are things. Updating faster, again, so the moment it's incorporated by reference, you've got a new standard that people need to pay for. Obviously, the downside is the best standard is now the standard incorporated by reference is already over date. I have 22 seconds, AI and licensing. Obviously, there's a whole nother AI panel. That's, again, what I'm going to talk to people in Frankfurt next week about AI and licensing for standards. If anyone's there, seek me out. With that said, there is opportunity for licensing AI, and you need to make your content available for AI in terms of tagging, enrichment, XML, things like that. But if you do that, there will be opportunity. My time is up. Thank you. I hope there's questions.
Oh, thank you, Roy. We're now through all the panel, and as I promised, we have a lot of time for questions. So if anybody has a question, feel free to raise your hand. I think you all have microphones at the table, and we'll take them. Till anybody jumps up, I have a couple questions maybe we could start with. And I want to follow up on something that Miriam just touched on, and it sort of addressed one of the slides I had early on about the Veterans Administration incorporating by reference the entire life safety code when they are really only focused on cemeteries. And it sounds like you've just proposed a potential solution to that, which is either get the VA to say we're only incorporating Chapter X relating to cemeteries, or they might separate that chapter out and make it its own module, for lack of a better word. Are there any impediments that you see to that model working going forward? But I will say, first of all, obviously for some organizations, like if you're a model building code, usually the entire thing gets incorporated. So that's one potential hiccup there. But are there any other problems that you see with that model?
Not that I see from a practical, technical standpoint. I have no idea how or if it would affect the SDO. And it's possible that the SDO could produce that piece, whatever it would be, that would be strictly for the agency. And so then the text of the regulation would describe that piece as part of the broader standard. So, I mean, you wouldn't call it, if you took chapter 5 out of the life safety code, the regulations would still say chapter 5 of the life safety code. And so if anybody then wanted the life safety code or chapter 5, they would still have to go get the whole life safety code. But the piece that would be given to us, that would be provided by NFPA, since we've got this example, would be an SDO prepared piece that's just chapter 5 with the front matter of the life safety code on it. So that would be essentially what a number of agencies are already doing, except that they're creating their own piece by taking the original copyrighted material, and when it's possible, essentially breaking it up and then just giving us chapter 5. But that's not always possible for the agency to do, even if they could identify chapter 5, they can't actually, without violating the copyright agreement that they have with the SDO, they can't just take out chapter 5 and give it to us. So they have to give us the whole thing. So I think the impediments would be between the agency and the SDO figuring out exactly what it is, because if they can just take a piece out and they can describe it, then we can incorporate it. If the instruction is just to use the standard as it applies to some topic, so you've got a piece on page 5 and a piece on page 8, and then you got page 10 and maybe 15 through 17, but only certain paragraphs in there. Unless the SDO produces a separate publication, then even those pieces could not be provided to us, because the agency is looking at the topic and not at a specific citation within the standard.
So, well, we were fortunate to have an agency representative here. Maybe you could chime in on your reaction to that approach.
Yeah, I mean, second everything Miriam said, and I can give a practical example where this has come up for EPA, and we actually have this as one of the case studies on our website. We were looking for a test method to see, about ignitability of things that are involved in a brownfield cleanup. And ASTM had a method that was pretty close to what we needed, but the text that we actually wanted to use in our regulations kind of scattered through another method that was intended, I think, for water and not for soil. So in that case, the work that we did to kind of work with ASTM to create another new standard wasn't driven by this copyright consideration. It was driven by practical considerations of IBR. But we were, I think, with goodwill, with a lot of hard work from a lot of people, able to work with ASTM and a couple of their committees to get a standard that was a little bit more fit for purpose for what we needed to use to test ignitability in brownfield cleanup. And that took, it was warp speed, so it took months, probably 6 to 9 months to accomplish that, which is, months, not years, is warp speed in standards time. But that, that to do that for every time that we incorporate a standard, 4,500 times plus updates, that's a pretty intensive lift for everybody. So I think, building on what Miriam said, it absolutely can be done when everybody wants to work together. I will say that when we finished that standard, working with ASTM and working through a consensus process, the discussion and the dialogue of us working with other experts from industry and NGOs resulted, I think, in something that, our program said that they didn't get any negative comments on that part of our proposed regulation, which is pretty staggering. I think we worked out a lot of the technical issues before the regulation went to comment. So there was a lot of good that came of that, but it is a resource-intensive proposition. So doing that every time, I think, would be probably tough for SDOs and for us. But I think it is a channel worth exploring for sure.
If I could respond to that, we've been talking about cost recovery, and what you've just been saying adds costs from the SDO perspective, as well as from the agency perspective. And so we do need to be thinking about, is that one step forward and two back, or just the opposite? A second point to Miriam's comment is there would be some back and forth, because if what the agency has tried to do is adopt certain concepts that are scattered throughout different sections, and the SDO then tries to get a collection of sections where that topic occurs, does that actually capture everything that the agency intended to incorporate? And if not, do we have a problem? And then the third point is simply that the SDO has to follow its own rules as well, because the SDO approves a standard for publication. If we were now creating a different document, is there any substantive change that goes along with that, or is it simply literally excerpts? And does the SDO authorize that kind of publication?
Stephanie, do you have any thoughts on this from the perspective of a standards development organization?
Well, what just made me think of that was something that Michael had just said, was doing the excerpts, what do we call it? Because if there's any changes, I'm not calling it ANSI ASHRAE anymore, I'm calling it ASHRAE. It won't be called ANSI anymore. So I think if we go down that path, it would clearly have to be, this is a document with excerpts from ANSI ASHRAE standard, whichever was being done. So that's a question from an do we want to do that, and how frequently we want to do that? And do we limit it to agencies maybe? I don't know, but that is a different, but it is another cost perspective too, to do that. It's more staff time, volunteer time, to make sure what we excerpt is correct from the technical experts.
So, your question out there?
Yeah, thank you very much. Mary McKeel, and I'm with the American Academy of Forensic Sciences, the Academy Standards Board, and I was very glad that the topic of the DNA came up earlier. Our organization, and I know ASTM and a couple others are involved in developing standards now, voluntary consensus standards for the use in forensic sciences. And that's a very important thing relative to how the scientists as well as the lawyers understand what's going on in forensic science. Well, DNA has been the golden child of the forensics. Even DNA, in terms of standards that are being developed, methodologies that are being put into standards, there are changes there that are happening that I think also change the landscape of how considerations will be taken in law. But what I really wanted to ask was, or to comment on, when a regulation, as far as I recall, when a regulation is put into play, it takes a lot of people, and it takes a lot of federal workers. And those federal workers are paid by taxpayer dollars. And we love paying Elise and Miriam, don't get me wrong, but what if standards didn't exist? What if there were no voluntary consensus standards? What would the agencies do? They would spend an enormous more amount of time trying to figure out methodologies, scientific research. It would be cost prohibitive beyond, at one point, about 30 years ago, I asked somebody at EPA, well, how much money does it cost to issue a regulation? And this is back about 30 years ago, and the answer was, $1 million to $2 million. Can you imagine, and that's just a regulation, can you imagine what it would be like to not have standards available to our agencies? And the reason I'm raising this is the issue of transformative. Aren't standards, couldn't you argue that the availability of voluntary consensus standards is in itself transformative to how regulations are able to be out there? to the completion of regulations that are necessary for safety and public health. And they wouldn't be out on the market if there wasn't the ability to incorporate the voluntary consensus standards that are done by work in committees. It's really just a question, but when I think about the term about transformative and what courts might consider to be fair use, I wondered if there isn't something in the legal system that might take into consideration the fact that it would cost Americans a heck of a lot more to have regulations if we didn't have the voluntary consensus standards.
Take that.
Yes, I agree. And that is also part of the analysis that you see in all of these cases, the difference between static and dynamic analysis. If you had only one standard and you were never going to create any more standards, kind of doesn't matter how you allocate the costs of developing them. But if you are going to continue developing and updating standards, you do have to take into account where's the money for that going to come from. And that's a factor that I think the ASTM court underweighted.
If I may, unfortunately, there is a court decision, right? And so now, how do you go around that? One is maybe there's an appeal and maybe the Supreme Court rules and maybe the Supreme Court rules in favor of ASTM, or you try to go around it through Congress, which is the point of the Pro Codes Act. I did want to make another point relevant to it's not just the cost of governments developing the standards. For those of us, and I imagine it's almost everyone who's either worked with or for a government pretty intensely, that there are politics. That's in fact where politics lives. And once you get into the idea of the government selecting the standards, putting a thumb on the scale, it's not just that they're paying for it, it's they're influencing it in a way that happens in other countries. And the fact that we in the United States do things differently, I think leads to higher quality and more internationally recognized standards. So, once the government becomes the funder, the creator, it raises a host of issues above and beyond costs.
I have a question. It's a follow-up to the charging government's comment.
Could you grab your microphone? I'm sure at least the online people won't hear you.
It should just turn off.
Oh, okay.
Said it was on, so I don't know. Thank you. I have a question, a follow-up to the charging the government's comment that was made. And I realize this may be somewhat of a touchy question, but to the extent that a government doesn't want to pay, who requested to pay, or a government agency incorporates a standard without the SDO's consent, what does the panel think about a takings claim against the government under the Fifth Amendment?
I know that let me just not so much repeat as amplify the question first, which I believe was on the issue of the takings clause under the US Constitution. If let's imagine a standards organization that has read the ASTM decision and decides to narrow the content of the published standard and move a whole lot of value into a guide. And the guide says, the standard says anyone should feel free to incorporate this by reference. And the guide says, we strongly object to anyone incorporating this by reference. We do not want that to happen. We are not asking anyone to do so. We want money if you want it and come to us for a license. So that's kind of the scenario that I think you're imagining. I can tell you that in one of the amicus briefs that was filed in the ASTM case, that issue was flagged, that there is a takings issue. I don't think the opinion addressed it at all.
No,
So-
and honestly, I can't remember if it's the practice management or the CCC case. At least one of those two cases from the 90s did flag this as a potential concern. But bear in mind, those cases found that there was no loss of copyright, so there wasn't a taking in that circumstance. And we did raise that in the ASTM case as well. It was never ruled on by either the district court or the appellate court. I think the counter argument to that, just so everybody's clear, is, especially in the context of fair use, if it was a fair use, nothing was taken from you. It was, you still have the copyright. All the cases that have been decided addressing this issue conclude that at least the model standard or code as a model retains its copyright protection. The question is there any copyright protection in things that are posted as the law once it's incorporated? But the other point is, to the extent something was taken, what I've heard opponents of the takings clause argument say is you never really had it in the first place. Like, you thought that your copyright meant you could stop governments from incorporating by reference, but you really didn't ever have that right, so nothing was taken away. Go ahead.
My name is Russ Cheney. I'm retired CEO at IAMO, one of ANSI's SDOs in question. And let me compliment you guys. This has been a really great discussion, touching on many of the issues that we as SDOs have had to deal with since past 15, 20 years. I mean, the issues that we've been discussing at the federal level are very, very critical, important to us. But it gets further complicated when you have 44,000 municipalities throughout the United States that amend our codes, change them to some degree, amend out some provisions. So, it's not practical in many cases to fight the problem that way. Stephanie made a great suggestion about, SDOs looking for other revenue sources to make up for, the lack of sales of our copyrighted documents. And that, in my view, is a more practical way while we continue to fight and promote the Pro Codes Act. But we have to realize that, some of the alternatives that we've been considering are just really unpractical when you consider the broader concerns relating to local, state and local adoptions.
Yeah, I mean, I think that's a fair point. That also plays into the takings thing. If you lose copyright once works incorporated by reference, who's going to be the first municipality to adopt it and be the one who took the copyright? Are they going to pay for all of it? And if that's not the solution, how are we going to track down each of the 44,000 municipalities that have incorporated a work by reference? So there are real problems with trying to solve this through either a takings type lawsuit or a government pays type idea.
And that's even before you get to the issues of sovereign immunity and government immunity. So you can file the lawsuit, but do they have to defend it?
That's a good point. Another question? Go ahead in the back.
Hi, this is Mary Saunders with ANSI. And I'm going back, I think, a little bit to Mary McKeel's comment. And I'm not a lawyer, but I was engaged, and probably still am engaged on the private sector side with incorporation by reference back to the PHMSA issues and the first revision of the NARA guidance. But it strikes me, so the NTTAA and then the circular both speak to the importance to value to government and to the regulated public, and the contributions to efficiency, effectiveness, as well as to protecting public health and safety and security of this practice of incorporating by reference, and also respecting the copyright of the copyright owners. And we've achieved over more than 20 years since the passage of the NTTAA and the NARA guidance updates and the revision of the OMB circular, this very careful balance of interests. At least I think those of us on the policy side always thought there was a very careful balance of interests that bring greater benefit than harm to the regulated public, to the general public, to whatever. And it just strikes me, probably because I'm not a lawyer, that I know there are legal issues. Copyright is a law, and so on and so forth. But how do we're meshing legal issues with greater public, with equivalent public health and policy and improvement to the economy and to the public as a whole, and mashing them into their contrast, as Carrie was saying, they're up against legal issues. And I think to Mary's point, it's not that voluntary consensus standards would not continue to exist. They would continue to exist because it is not the sole purpose of voluntary consensus standards or any standard to serve to support regulation. But it's a very important shared responsibility and shared function that is being affected by these legal cases, because some SDOs will not want their standards to be incorporated by reference because there is a cost associated with it. And I think the courts certainly, from my perspective, undervalue the value of that infrastructure that underpins the resulting standards. And it's not a one and done deal, it's a continuous maintenance process. And I don't know how do we address that, this mashing up between, broader public policy interests, I say, and legal issues. There's got to be a better way.
Anyone have any thoughts on that? I mean, my initial reaction to that is hopefully the Pro Codes Act maybe will resolve that issue. I mean, it's tough to do this on a standard by standard, use by use basis. And, in some ways it would make sense for Congress to step in and just resolve this in a way that appropriately balances both the needs of standards development organizations and the need of the public to be able to understand their legal obligations. Everything seemed to be going fine for 20 or 30 years. When the ASTM case was first filed, and and Public Resource was posting these standards online, we kept saying it seemed like it was a solution in search of a problem. We didn't think there was a problem then. Everybody had, well, not everybody, but most folks had online reading rooms, and there wasn't really an access problem. And there still has never been in any of these lawsuits a person who came forward and said, I was impacted by this standard and I couldn't figure out what it said. It's just not the case. Yeah, go ahead.
Andy Updegrove, I just want to point one thing out about the Pro Codes Act, which I think is a very serious flaw, and that is that it covers only standards that are created by standards organizations that meet the OMB A119 definition. We ran into the same thing with the BIS entity rule, where originally the protection was only going to extend to OMB A119 qualifying organizations. They eventually corrected that and said that the carve out in the safe harbor will apply to all standards organizations. Here we are again in the Pro Codes Act, where it's only going to protect one type of standards organization. And if what we're talking about is incentivizing creating standards for the public good, there's no justification for narrowing it to one type of organization. Now, to be fair, the great majority of the standards that are going to be referenced and have been referenced do come from SDO accredited and similar organizations. But when you get into things like privacy, when you get into things like cybersecurity, when you get into things like AI, all of which are going to be standards that are going to be referenced into law, many of those are not going to come from ANSI type accredited organizations. I don't know why it's in there within ANSI. I raised the issue and hope that we could do something about it, but there it sits. And to the extent that any of you are talking about or trying to influence this, I would just like to point out that there's no real justification for this. So even if it goes through, it's a partial solution without a justification. Thank you.
Good morning, I'm Tim Klein. I'm the Standards Executive at the U.S. Department of Transportation. I wanted to point out a couple things. One is, you may have heard we're building a lot of infrastructure everywhere. And there are literally thousands of standards, test procedures, and conformity assessment activities at multiple levels of government, not to mention tribal governments, that I would hate to have to pay on every project. Our costs are going up as enough, and no one has even addressed that side of things. Let me just throw that on the table. Second thing I just would like people to know is when this ruling came out, the very next day I had a phone call from two of our regulatory offices, one saying, oh wow, now do I have to post all my incorporated by reference standards, speaking of takings, and the other one who really wanted to say, oh wow, can I go do this now? Take that for what it's worth. I gave them the same answer in both cases. But then the third thing, I'd like to take a little more of the international angle on this that you all discussed. Transportation, by its very nature. We are very involved in international standardization in aviation, maritime, and dangerous good movements through ICAO, IMO, and the UN Dangerous Goods Committee. How in the world, how does this affect that where we're trying to come to international standards, which may or may not be created ultimately by US domiciled SDOs, but also where we're getting pressure to have alternate means of compliance to meet international safety requirements. Thanks.
Oh, does anybody on the panel have any thoughts on that one before we move on to another question?
I got the same questions right after.
We were hoping for easy questions,
Yeah,
if you
thanks,
could
Matt.
make them easier.
So,
Great.
yeah, the international component's really interesting because then you have a different type of taking, I suppose, which I've never really thought through. So again, that's a really great question, but it does complicate everything. So if I'm or if I'm a standards organization developer in another country, I may now actively not want to be in the US because I don't want to lose, and we shouldn't say not lose copyright. So let's be clear, it's a fair use decision means there's an infringement and the infringement is excused. It doesn't mean there's no copyright ability, but it does impact vastly on your ability to sustainably license that. So again, you still maintain copyright, you just can't really take advantage in certain circumstances of the economic values that you're supposed to get under copyright. And back to the prior point about transportation not wanting to spend more money, I don't blame you, right? We get that. I don't think anyone here, well, I won't speak for others. I don't think that these are good, positive, great policy solutions. These are the world that we're living in, and everything needs to be on the table in terms of sustainability, because if we don't get sustainability right, then we don't have great standards.
You made me think of one other point, which is what will be the effect on the competitiveness of US-based standards organizations. Would the effect of this ruling shift some standards development to countries where standards organizations have different financial models, for example, more government support? And that will vary by the kind of standard at issue, but that would be something one should be thinking about.
Okay, so back there.
Thanks. So just one complicating factor. So on Tim's testing.
Yeah.
It's working. So one complicating factor on Tim's, Gordon Gillerman NIST, sorry. On Tim's point, agencies just don't want to use international standards. They actually have to use international standards as their first choice in regulation under our WTO TBT regulations, and that's a part of our law, right? So, the regulatory agencies are driven to look at the use of international standards to meet their regulatory mission needs as the first course of regulating in the product space, for sure, under the TBT agreement that's in law through the Trade Agreements Act. The other one is just a point that Andy made, is that OMBA 119 was revised in 2016, and it actually recognizes not just voluntary consensus standards used by government agencies, but also this broad category of other standards which are developed in a process that doesn't meet all the principles of voluntary consensus standards. So OMB has raised its aperture to address exactly the point that Andy's made, and so that needs to be thought about in the broadening of this as well. Thanks.
Jordana?
Just want to make sure you can hear me.
Yep.
Jordana Rubel from ICC. I wanted to make the point, it sounds like others have already recognized this, that when the courts have been discussing the public interest that's at stake here, they're really taking a very narrow view of what that public interest is by focusing on the need for the public to have access to the standards and codes that have been incorporated by reference. It sounds like there's a broad recognition, at least in this room, that there's other important public interests at stake here. I'm very heartened to see so many government agencies represented in the room. And I do understand, I used to work for the federal government myself, so I do understand that it's difficult to get involved in litigation if you are working at the federal government. But I think you do have a couple of potential opportunities now, and I hope you will use your voices in those processes. One is in supporting the Pro Codes Act, as we've discussed. And the second is if there is a cert petition in the ASTM case, there will be a collection of government views. And at that time, I hope you will speak loudly in support of the SDOs. Thanks.
Yeah, I mean, one more point on that. There are even other opportunities beyond the ASTM potential cert petition and pro codes. As I alluded to in one of my slides, there are many other litigations going on. I'm involved in some of them. If anybody wants to figure out how to get involved, I'll either help you with the cases I'm involved in or point you in the right direction of folks who are handling those other matters. I see we're out of time now, so I want to thank all of our panelists for taking the time to be with us today. Please join me in.
So welcome back, everyone. We're going to get started. It's my pleasure to introduce the moderator for our second panel, Justin Pierce. Justin is a partner with the Venable Law Firm and is a co-chair of Venable's Intellectual Property Division. Justin has significant experience advising companies and their executives on how best to acquire, develop, and apply their intellectual property to achieve their business objectives. He's guided clients through a wide range of matters involving patent litigation, trademark, and brand protection, anti-counterfeiting initiatives, copyright, design rights, trade secrets, and licensing. Justin is also well-versed in strategies for handling rights of publicity, domain name, and social media disputes. He routinely advises companies with respect to artificial intelligence and cutting-edge issues involving intellectual property. Please join me in welcoming Justin Pierce.
All right, thank you. Good afternoon, everyone. So I must warn you, it's always interesting when you have the panel presentation right after lunch. I've got three things that'll save us, though. One, I think this is an exciting topic, and based on some of the interaction and questions from the audience here, I think all of you, for various reasons, are quite engaged in this topic overall. Second, the lineup that I'm about to introduce is excitement in and of itself. And then third, I'll warn you, if I do see eyes dropping or chins going down, I did serve in the military before and love doing these speeches to my team. If you ever met anybody from my firm at Venable, I always get subbed in to do a lot of the firm addresses, particularly if it's a boring topic, because I'm very famous for getting people up to do jumping jacks and push-ups, and we can do PT in the middle of the session and help you get in shape, help you stay alert, but hopefully we can stay away from that. So without further ado, like you've already heard from the introduction, I'm Justin Pierce from the Venable Law Firm, worked in the copyright and intellectual property space for a number of years. What makes this whole topic really interesting to me is we kind of focus in on the copyright implications of using AI to develop standards. It's just how much knowledge, whether it's on the technological side, but also on the legal side in the world that I deal with, in every industry that I touch. There's probably not a client or a company or organization that I'm giving counseling to or representing in some way where AI isn't playing a big role in their current and certainly future plans. And so with that, let me introduce our panel. And what I'll do is kind of break this up. I'll introduce, you all obviously have the slide there, but I'll introduce, starting with Jonathan here, let him do his sort of 10-minute piece, and then we'll go down the row with Ivy, and then to Michael, and then to Hussein. So first of all, introduce Jonathan Band, who's a well-known copyright and IP expert. He's helped a lot to shape the laws around governing intellectual property in the internet through a combination of legislative and appellate advocacy. He's a Harvard and Yale grad. Worked in DC for a number of years. We had a good talk about some of his time at Morrison Foerster. And I see also he was an adjunct at Georgetown University, where I've also taught as an adjunct. So Jonathan, we'll turn to you for your presentation.
Thank you very much, Justin, and thank you all for having me here today. So what I'm going to do is give a quick overview of the copyright issues relating to generative artificial intelligence. And it's a topic that one could talk about endlessly, and we'll have more time in the Q&A. But again, this is just a very, very high-level overview. So the most important thing that you should take away from this presentation is that there are really 3 different copyright issues implicated by generative AI. And so you'll hear a lot about copyright in the AI context, but it's really important to sort of dig down into which of these questions one's talking about. And when you read articles in the newspaper, they kind of shift from one of these topics to the other, and it gets all confusing, and you get confused as the reader, and the reason you were confused is because the reporters are confused. There really are 3 different issues. So the first is, does the ingestion of copyrighted material for the purpose of training the artificial intelligence, does that constitute copyright infringement? The second is, does the output of the generative AI system, does the output infringe copyright? And then the third question is the output copyrightable? And Ivy is going to talk a lot more about that third question, so I'll talk more about the first 2. But the important thing what's also sort of interesting about this is with the first 2, that's sort of more like, okay, well, there's an implication of how AI can be a bad thing. It's infringing, right? The training may be infringing, the output may be infringing, but then you switch to the third question. It's like, oh, okay, well, maybe it's infringing, but how can I use it, and how can I make sure that what I do with it is protectable? Okay, so there's definitely, depending on who you are and your view of the world, there might be different attitudes towards these 3 questions, but it's worth noting that with the first 2, there's somewhat of a skeptical or hostile attitude towards AI. And with the third one, there's almost like, okay, how can people use it to their advantage?
I want to touch it. If you're on Zoom or video conference, can you please mute for us?
Okay, so turning to the first question, does ingestion infringe? So as I was saying to my colleagues during lunch, my undergraduate background was in social studies. That's what my major was called. I really don't know very much about technology at all. So this is a gross oversimplification. I'm sure there'll be others in the room who know a lot more about how the technology actually works than I do. But to make it a very complicated story simple, training artificial intelligence requires the ingestion of millions of works. And typically you have bots, little software spiders crawling the internet, downloading lots of material into what's called a training database. Software then analyzes all of these works to discover patterns, relationships, and trends, which then become reflected in an artificial intelligence model. Now, some people say the model comes first and then it's fine-tuned by the training data. Other people say it's the other way around. And I'm sure the answer is somewhere in between, or probably it depends. Now, again, but still, either way, you have a lot of copying of copyrighted content. And most of the countries that have examined this issue have determined that ingestion for AI purposes does not infringe. Now, you see I have an asterisk because that's sort of my view of the current state of the law, but as Justin indicated, this is a rapidly changing area, and so while that might be true right now, it might not be true in a couple of weeks. So, but I think there are legal theories in most of the countries that have looked at this issue that do support that statement. Okay, so in this country, the theory that is likely to allow all of that copying is fair use, and we spoke about fair use a lot in the previous panel. And here, several courts have found that, kind of all the copying and the assembly of these huge training databases for AI functions such as search and plagiarism detection are fair uses. And so there's, these cases have come up over the past 15, 20 years, and these are appellate court decisions, not just district court decisions. But the AI functions that were looked at were more basic. They weren't generative AI. In other words, they weren't producing copyrighted works as their output. And so therefore, they're less likely to have a competitive impact. And we saw with the fourth fair use factor, the harm to the market for the work is key. So that's going to be very important in how these cases get analyzed. And the cases, several cases have been already filed in the generative AI context, including one by Sarah Silverman as part of a class action. And then there was another class action that was more recently filed involving a bunch of mystery authors and the Authors Guild. So it'll really be interesting to see whether the courts sort of say that this is more similar to the previous cases dealing with AI, or see generative AI as something different because of the theoretical possibility of competitive harm. What's just interesting in this context is Israel, which has a fair use statute based on our fair use provision, their Ministry of Justice recently came out with an opinion letter saying that the copying that is involved with machine learning is a fair use. And during the Q&A, we can go into this in more detail about what the situation is in other countries like the European Union, Singapore, and Japan, but they've all looked at this issue as well about the ingestion for training purposes. Now, shifting to the second question is, does the output infringe? There we have, lots and lots of case law, a century and a half or more of case law looking at how do you assess whether something is a work that a person produces is infringing on the work of someone who came before. And so typically, there's two big questions there. Was there access to the original work? And then second, was the output substantially similar in protected expression? That's the legal term that we always look for in copyright cases. Was it substantially similar in protected expression? So the good news is we have lots of case law. The bad news is that the case law is completely incomprehensible. It's very complicated because you're trying to look at this question about whether something is substantially similar in protected expression. If the output is identical to something that was input, that's kind of easy, right? If the output is identical to something that was in the training data, okay, clearly infringing. But typically it's not going to be identical, it'll be similar. And then the question is, how similar is it? And is it similar in a way that's infringing? This is a very complicated issue. And then the second very complicated issue is who is liable for the infringing content? Meaning, is it the AI provider? Is it OpenAI that produced ChatGPT? Or is it the user who put in all the prompts that produce the infringing output? Is it both of them? Who is the direct infringer? Who is the secondary infringer? And that matters because if you're a direct infringer, there's strict liability. If you're an indirect infringer, the secondary infringer, you have to have knowledge and intent, and it's a higher bar to cross. So these are very complicated issues that will have to be resolved in the future. And so, this is going to be an interesting and very messy area. The third question, as I mentioned, Ivy is going to talk about more, so I'm going to not really go into that other than to say that in general, if the output is entirely created by the machine, then it is not copyrightable in most countries except for the UK. But chances are that in most cases, there's going to be a degree of human input, and then the question is that degree enough? And if it is enough, then the output might be copyrightable. But that, again, is an area that's going to have to be determined in the future through litigation. And that's my 10 minutes. Thank you very much.
All right, thank you, Jonathan. Appreciate it. You raised some good issues there. We'll definitely dive back in. Let's move to Ivy. Ivy is a director at the Stern Kessler Law Firm. She is someone who's had a wide variety of practice areas where she has touched on rights such as design rights and brand protection for clients, intellectual property prosecution in the area of trademark, copyrights, and design patents as well. And she's had a lot of experience before the USPTO and U.S. Copyright Review Board in inter-partes proceedings before the USCTAB or Trademark Trial and Appeal Board.
Thank you for that introduction. So I'll be focusing on the copyrightable aspects of AI-generated works. So first, I wanted to orient all of us to some copyright principles. So we heard in the panel earlier what a copyright is, but just to remind ourselves, it's an intellectual property right that allows the copyright owner to stop another party from recreating a work. So this means that the copyright owner can stop another party from engaging in certain types of activities, including copying, distributing, or preparing derivatives of a copyrighted work. So in order to be copyrightable, a work has to satisfy three things. The first is that it has to actually be created in a form that is that can be physically be perceived. So this means that you just have to be able to see the work, for example. It can't exist in your mind. The second is that it has to be independently created. And this means that you didn't copy it from something that is pre-existing. And then the third requirement is that it has to be sufficiently creative, and that's a low threshold to meet. So once all three things are met, the work is automatically under copyright protection. And the owner of the copyright in that work is the creator, unless the creator has assigned the copyright in the work to another party or has designated the work a work made for hire in a written agreement. So because a work that is independently created and sufficiently creative is under copyright protection the moment it's fixed in a form that can be perceived, there's not actually a requirement to register the work with the Copyright Office. But it's advisable to get a copyright registration because having a copyright registration provides additional benefits, including the ability to bring a copyright lawsuit against an accused copyright infringer. So to get a copyright registration, you have to fill out a copyright application like the one that's shown on the screen. And you can see that that copyright application includes fields for providing the details of the author and of the owner of the work. So this brings us to the question of who is the author and the copyright owner of a work including AI-generated content. So the answer to the ownership question, or to the ownership part of that question, is going to depend on the terms of the AI service that is used. So if we take a look at OpenAI's terms of use for the ChatGPT tool, it states that the user owns all input. So this makes sense because we just said that the creator is the copyright owner. And this assumes that the creator did not copy it from something else. And then it says, as to the generated output, it says, OpenAI hereby assigns to the user all its right, title, and interest in the output. So this to me suggests that the original owner, the original copyright owner of the AI-generated work is OpenAI and not the user. And it's only by that assignment language that the user now becomes the owner of any copyrightable aspects in that AI-generated content. So this wording additionally suggests some things about the author question. So I think it confirms that the author of the input is the creator, assuming that the creator did not copy it from something that is pre-existing. But what it also, to me, suggests about the output is that the user is not the author of the output, but rather it's something else, and maybe it's OpenAI. So if that's true, what does that mean about the copyrightability and the registrability of AI-generated works? So to answer this question, I thought it would be instructive for us to take a look at 3 cases decided by the Copyright Office involving the copyrightability of 3 works. So the first work we'll take a look at is the work shown here. It's called A Recent Entrance to Paradise. So the owner of the work, Stephen Thaler, who some of you might know is a renowned computer scientist and a prolific inventor, filed a copyright application to register this work with the Copyright Office. In the copyright application, he identified the author of the image as Creativity Machine. He also included a note in the copyright application stating that the Creativity Machine used a computer algorithm to generate the image autonomously. So if you all were paying attention to the comment that Jonathan made earlier, do you, by a show of hands, who wants to say that this work was found to be registrable? No one. Good. You all were listening. So according to the Copyright Office and more recently the DC District Court, this work is not copyrightable and therefore not registrable. And in their decision, they indicated that courts have always interpreted the statutory phrase original works of authorship, which is required to be copyrightable, to require a human creation. And because this work was generated autonomously without any human contribution, it therefore could not meet that standard and is therefore not copyrightable and not registrable. So the next work that we'll take a look at is titled, I won't say the title because I can't pronounce it, I'm just going to call it The Work. But the work at issue is the one that's on the image in the right corner. And so the owner of the work filed a copyright application to register the work with the Copyright Office. And in his application, he identified himself, Jason Allen, as the author of the work. While the application was awaiting examination with the Copyright Office caught wind of media reports that heralded this work as being the first AI-generated image to win an art competition. So the Copyright Office reached out to Mr. Allen and asked him, can you please clarify the nature of your contribution to this work? In response, Mr. Allen informed the Copyright Office that his contribution included inputting a series of at least 624 text prompts into the Midjourney AI software. And what the Midjourney raw image looks like is the image that's on the left below. And then Mr. Allen used Photoshop to modify that AI-generated image to add additional detail, which is indicated by the arrows in the image on the right. And then he used another tool to upscale the image. And the work on the right is the image that he wanted to register with the Copyright Office. So by a show of hands, how many of you think that the Copyright Office agreed to register this work? Okay, let's see. So according to the Copyright Office, based on the information that Mr. Allen provided, although the portions that he did author would be copyrightable, he needed to disclaim copyright in the material generated by AI before the Copyright Office would issue a registration. What this means is that any copyright would not extend to the portions that the AI generated and would only protect the portions that Mr. Allen created, which are the portions indicated by the arrows. Mr. Allen refused to disclaim any copyright in the material generated by the AI, and so the Copyright Office said, sorry, we're not going to register this work. And then the last case that we'll look at is this comic book called Zarya of the Dawn. So Miss Christina Kashtanova filed a copyright application to register this comic book with the Copyright Office. She identified herself as the author of the work, and the Copyright Office registered the comic book without any issue. After the copyright registration was issued, the Copyright Office learned of Ms. Kashtanovas statements on social media that she used Midjourney AI to generate the comic book. So based on that information, the Copyright Office reached out to Ms. Castanova, asking her to clarify the nature of her contribution to the work versus Midjourney's AI's contribution. And Ms. Castanova informed the Copyright Office that the AI tool created all of the digital images in the comic book, but that she herself authored all of the text, and she also took the images that were generated by the AI and she compiled it into the finished form that became the comic book that she registered. So by a show of hands, who wants to say that this registration was maintained? Okay. So what happened here is the Copyright Office agreed that there are elements here that are copyrightable. They confirmed that the portions that Ms. Castanova herself authored, the text, is copyrightable. They also said that the specific arrangement of the text with the AI-generated images are also copyrightable. But they said that the images generated by AI alone, by themselves, would not be copyrightable. And so what they ended up doing here was they ended up canceling the original registration and issuing what's called a supplemental registration, saying that the only thing that is copyrighted here are the human-authored works. The copyright does not extend to any of the digital images because they are generated by AI. So for those of you in the standards industry who are thinking of using AI to generate a set of standards or maybe using it to create images, some tips to consider for improving its copyrightability or registrability is literally adding a human touch to the work. So we saw from the last case that sometimes even just compiling things can be enough to improve copyrightability. And then if you are going to file a copyright application to register the work, you'll need to remember to specify which portions of the work are generated by AI. You don't, however, need to specify which specific AI tool that you used. And if you still have more questions, the Copyright Office has put out guidance, and it's accessible at that link on the slide.
Thank you, Ivy. We now move to our next panelist, Michael Lindsay, who's doing double duty today. So we ought to give him a quick round of applause. Michael's going to talk to us from the perspective of SDOs. Michael's also a longtime experienced partner at the law firm of Dorsey and Whitney. I know he represents IEEE and will provide an overview of the SDO perspective here on this particular panel.
Thank you very much for that introduction. First of all, let me say that I recognize that this is the second time you're seeing me today, so in order to keep things fresh, I changed bow ties.
I did notice. I love it.
And in case you don't believe me, here's the other one, and yes, I tie them by hand. So I once again find myself in the position of having a bit of overlap with what our prior speakers have said. And again, I think that is good to have perspectives from different vantages. And I also think that as when you look at some of my slides, you'll see that that some of the material that was not copyrightable appears in more than one place now. So I think before we talk about copyright law, we should step back and ask ourselves, what is the SDO trying to achieve? Why does it want the benefits of copyright law, and how does that help? So the first objective is that a standards organization wants to publish high-quality standards. And they seek that because if those standards are then broadly adopted, they need to be high quality, otherwise they're just not going to achieve their purpose. Of course, the targeted degree of quality could vary by industry and by nature of code, but no one wants to put out a poor quality standard. They want to put out something that can be used in the real world. And they do so because sometimes standardization picks one particular approach to a problem. It doesn't matter which approach you pick, you just need to have one that everyone agrees on. A second objective is that broad adoption. An SDO wants to see that its standards are adopted broadly and are actually doing some good in the real world, because that broad adoption maximizes the social value of that standard. It maximizes the value of the work of a whole bunch of volunteers who've spent a lot of time working on the text of the standard. Of course, we could add a third objective, but you kind of already know that one from this morning's discussion. The SDO wants to recover its costs. It does need to be self-sustaining if it's going to continue its work. So I wanted to talk first about generative AI and that first SDO objective, namely quality. So before you even get to the questions that copyright law poses, you have to ask, is generative AI currently capable of producing consistently and reliable the kind of quality that an SDO requires? And yet, this is not for the final product, this is just for some component of it. Can generative AI, as it exists today, do that? Well, we have two problems. One is the problem of hallucination, and the other I've put into a separate category. I'll call it the problem of opinion, and I'll explain why I put that into a separate category in a moment. But there have been a lot of headlines about what's happening with generative AI in my profession, the legal profession. Judges are not reacting well to it. Now, as our keynote speaker said this morning, the Supreme Court of my home state, Minnesota, rejected DNA evidence for a while. I'm pleased to report that the Supreme Court turned itself around later. So yes, even in Minnesota, science does progress. But this is a real problem. A judge who receives a brief that has been written by a machine wants to know that that brief is still reliable. They also want to know that the advocate is going to stand behind it. The second thing is, outside of the context of the brief that is going to the court, that generative AI is making statements that purport to be statements of fact. A statement of fact that isn't true can defame someone. So you have that kind of problem as well. So just a bit on the hallucination problem. The case that I mentioned, a lawyer's brief cited at least 6 cases, all with the proper legal citation format that simply did not exist, just completely made them up. Courts recognize that lawyers will use technology to assist themselves. They'll use human inputs of various kinds, but they'll also use various databases such as Lexis and Westlaw. And there's nothing wrong with technological advances as long as the lawyers are using them responsibly. And in this particular case, the attorneys at issue abandoned their responsibilities when they submitted these non-existent judicial opinions with fake quotes completely made up by AI. The other thing, how many have seen the movie Draft Day? Yeah, great movie. There's a wonderful line where the Browns coach says he doesn't want to pick a player because when they stuck a $100 bill at the end of a training book, and when players got to the end, they found the $100 bill. If they didn't get to the end, they didn't find it, and they were surprised to learn it. Well, there was one player who said that it wasn't there. In other words, he stuck with the lie. And that was the problem in this case. The lawyers didn't fess up early enough and clean up the problem. But I mention all of this because when you have people writing a standard, you want to make sure that there are human beings involved in that process. Now, I'm not a Luddite who thinks technology has no role. I was a pioneer in adopting video telephone calls, and it took a global pandemic for the rest of the world to catch up with that. But you do need to make sure that the people who are writing that standard can stand behind the quality. Now, I said there's another problem, which is the problem of opinion, and I separated this just in case there were people in the audience who might not agree with that proposition. But that's another example of something that generative AI can do, create an issue which, most people would agree doesn't actually exist. Now I want to go to the question of broad adoptability. It's advanced, of course, if the SDO can obtain copyright on its standards. Copyright law protects original works of authorship. It does include compilations and derivative works. And of course, I trust everyone in the room attended this morning's panel to learn more about that topic. But broad adoptability also means that the SDO should be able to publish its standard free of copyright infringement claims. And a lot of standards organizations adopt copyright policies for that reason. They might have participants sign on to it, or they might just repeatedly state it, and there's an implicit agreement to that. If someone is making a specific contribution of work, you want to make sure that you own that, you own a sufficient right to use that work that you can publish your standard. But that does create some questions. First of all, is the generative AI compilation copyrightable? You heard from our speaker this morning that maybe not, but you've also heard maybe yes, because as long as there's sufficient human interaction with that AI, you will meet the requirement of human authorship. You also want to know if the inputs that you are receiving that are then compiled are AI assisted, and if so, does that infringe copyright? So I'll go through these slides quickly just to demonstrate that our panel was not excessively coordinated when we put together our slide sets. But basically, copyright law requires a human author, and that human author independently create a work and that have at least some amount of creativity. So what happens with generative AI? Well, we've already seen this picture. It's actually, I personally like the color combination. I think it's lovely. And the good news is it's available for free. I downloaded this from the court opinion that actually republished it. But I believe that the next part of my presentation is indeed original, because you haven't, at least not today, seen this picture, which is the famous monkey selfie. So the question in that case was, there was literally no human involvement. There was simply technology. This picture was actually snapped by the monkey taking a picture of himself. But it's just meant to highlight the point that there has to be human involvement when you are using the generative AI if you want to be able to have a copyright. But the other question is, if you are using generative AI, does that itself constitute a copyright infringement? And there's a very recent case, Thomson Reuters versus Ross, that held that in the generative AI process, there was copying of the full text of Westlaw headnotes. So West Publishing, for more than a century, has published the opinions of courts of appeals and the US Supreme Court and various federal circuits. And it never claims copyright in the judicial opinions themselves. That's public domain. But it has this system of organizing cases, and it's called the West Keynote system, where they have propositions of law under particular subject matters. It's this enormous taxonomy. And then they have a summary point under the particular keynote heading. Now, if all that headnote is doing is copying the text of the opinion, it's not copyrightable. But sometimes it will add more. In fact, I've on occasion had the problem that the headnote states the proposition that I need to establish more clearly than the judicial opinion does, but unfortunately I can't cite the headnote as compelling authority. So in that case, was not clear to me whether the AI actually went out and got the head notes, so it was part of that process, or they were downloaded and handed to the AI. But in either event, the generative AI did copy it, and the court said that satisfies the copying portion. But everything else was a question of fact, so neither side was entitled to what's called summary judgment, that is a decision by the court without the jury, where a jury would otherwise be required. And those are the questions that are now going to a jury. For those of you who have been in litigation, you know that submitting a question to a jury is putting it into a black box. You'll get an answer, you have no idea how it's going to be generated, and you have no idea how consistent it's going to be across cases. So this is something to be watching for to see what happens at the end of that case. Just a couple of propositions from that court. These are some of the factors that a court is looking at. And there's always going to be a balance between, do we protect the interests of the creator or do we protect the interests of the copier? And how do we make sure that we get the right balance so that we encourage new creation, but without creating so many barriers that the work can't effectively be disseminated? So those are the kinds of questions in that first point. The second point was one that Jonathan mentioned about what's the public benefit of allowing AI to be trained with copyrighted material. As I was listening to those remarks, I was reminded of a program that I'm involved in called Reader Writer, where they pair up members of the community with students in school. The students write essays, the community members read them and give feedback on them. And one of the pieces of advice I always give to young writers is the best way to learn how to write is to read. Well, that's kind of what generative AI is doing. The difference is it might be copying the work instead of borrowing it from the library. So there's more that is going to happen in that case, and we shall find out. Finally, as I believe Jonathan mentioned, there are cases that are addressing this specific issue. These are both at the pleading stage. One's a lawsuit against OpenAI and one's a lawsuit against Meta. And they both are addressing the question of how much content can AI use to train itself, and does that mere act of training constitute an act of copyright infringement? Thank you.
All right, thank you. We're now going to move to introducing Hussein Hadi, who is the head of publishing at the International Organization of Standardization. And without further ado, Hussein is going to take us through his presentation, and he is on the video conference.
Hello, everyone. Joining you from Geneva in Switzerland. Delighted to be with you today. I'll be asking them to move to the next slide, please, if you don't mind. So we've very much covered the legal side of things here. I'm going to zoom out and talk about the broader context, and then discuss how ISO has responded to AI and what we see as predictions for the future. If we could go to the next slide, please. Okay, stay with me here. I'm using my own presentation for this. Okay, the first thing to say is we're looking. Let's define the broader context here. You can see here we have a slide from Gartner, which I feel is very useful to talk about the umbrella here of generative AI. And then we talk about foundational models, and then we look at large language models, and then we have the chatbots here. That's a very good overview, and this will be useful when I talk about the draft EU AI Act later on. On the next slide, please, where we look at the most commonly reported use cases of generative AI tools and the most cited risks of generative AI adoption. This is from a report from McKinsey. And this is important just to see if we put aside the hype, where is the reality of adoption here? And we can see that most of commonly used cases are in marketing and sales, product development, service operations. You can see the risks there. But the reality is, when you look at this, when you look at the study, the actual adoption of AI hasn't changed much across the board since last year, and is only being applied in very specific functions. Certainly, some industries are being more impacted than others, whether it's media or financial services are facing much more disruption. But it's important to remember that we need to take the hype with a pinch of salt. If you go to the next slide, where we look at where can AI-powered tools add value, and you can see here a helpful list of tools from IMD. From my perspective, it would be useful to talk about AI in the publishing sector. If you look at some of the major publishers, whether it's Elsevier and others across the world, most of the AI tools being used today in the publishing process are involving doing simple tasks well. Help me with a bibliography, help me with a translation, extract text from a PDF, help me with cross-references. So it's doing simple things rather well.
Hey, Hussein, this is Justin. I'm going to call an audible here just because you're on the video. We're having a little bit of a difficulty getting your slides running. So why don't we do this? Because you're going through some really good material and people don't have the benefit of your slides. If you don't mind stepping back a little bit, I think what we could do to fill the time in a way that might work, if you don't mind on the topic you were just discussing, maybe take us through a little bit step by step, but just knowing that at the moment, the audience can't see the slides while our tech team is working on it.
Oh, thank God. I thought you were going to call calisthenics time now.
Fair enough. The good thing is all slides will be shared, and I've included links to some of the reports I'm talking about. But yeah, just to take a step back with that, the World Economic Forum and McKinsey have, in the last few months, have produced really good reports looking at actual adoption of AI, specifically focusing on generative AI tools. Where is that being used? For our purposes, in terms of copyright, there's a lot of lessons to be learned from the publishing sector. Like I said there's specific tools out there that are helping with the pre-drafting phase, helping with the research phase, helping with brainstorming. If you look at LLMs specifically and how that can help in standards, I'd left out drafting standards out of this slide, which I'll come back to later. But for me, LLMs can really help with the interpretation and implementation of standards. So I don't know if any of you have actually used some of the LLMs when it comes to standards, but if you ask questions such as, what standards would help me build a self-assessment tool? And it's a really good selection that's put together, looking at user friendliness, looking at security, etc. If you say, summarize the requirements of this particular standard, or suggest a work plan for implementation, this is where, as it stands today, the LLMs really shine in bringing the standards to life and helping with the interpretation side of things. What I will do now is, with that in mind, before I come back to Aizo's response, I'll talk a little about the global AI ecosystem here. So at the moment, as of the end of 2022, there are 62 countries with a national AI strategy. As I'm speaking to you guys from Switzerland, we're very neutral about all this. We celebrate anything on that front.
All right. Hussein, let me interrupt you once more. This is good news, though. We got the slides working now.
Ah, fantastic.
I was going to go back because you're introducing some great terms like LLMs, large language models. And what I've done is I've gone back to your slide that has some of your refreshers or your definitions of key terms. If you don't mind, maybe kind of running through that for us.
Yeah, sure. So, when you talk about AI out there, first thing is we're talking about generative AI, which is our broader umbrella term here. And under that, you can have so many different aspects. When we're talking about ChatGPT specifically, it's a conversational chatbot, and you have an LLM on top of that. So just to be clear here about the terminology. So, for example, if you look at the EU AI Act, they're often referring to foundational models, and that's a key aspect in there. But of course, foundational model is under the umbrella of generative AI. So just to make that clear, and you've got some examples in there, but I do think this slide gives a really interesting working definition there of the different terms that we might use. But I will follow the panel here and refer to generative AI. If I ask that you go to the map, the slide with the map, if you wouldn't mind.
Yep, we're going there.
Thank you very much. So I would say that, yeah, Canada led the way with the first national AI strategy back in 2017. Since then, a lot of others have followed. Interestingly, you look at the United Arab Emirates, for example, they have a Minister of State for AI and Digital Economy, and they've been very proactive. They've actually published some interesting reports you can access online, looking at 100 use cases for generative AI in media, 100 use cases for generative AI. So they're actually putting out the use cases and encouraging the use of AI. So it's interesting to see the different approach there. If we go to the next slide, please. Obviously, national standards bodies have responded and are putting together their own roadmap for how standards can help with AI. So China was one of the first to put together a roadmap, but since then you've had many others. Ireland, one of the most recent ones. Ireland's roadmap is very much focused on supporting the implementation of the EU Draft AI Act, whereas BSI, the British one, is an all-encompassing white paper looking at the broader ecosystem. But these are very interesting to read to see how national standards bodies are tackling this and where they want to go next. If we go to the next slide, please. In terms of global developments, there's been a lot of attempts to produce voluntary guidelines, whether it's initially the OECD AI principles, UNESCO recommendations on the ethics of AI. From the private sector, you've got the AI Governance Alliance from the World Economic Forum, and most recently, the United Nations Digital Compact, where there's been discussions of a AI Council. And of course, there's been a lot of events. The Deputy Secretary General of ISO is at the AI Summit in Amsterdam this week, and we have two big AI events happening in the UK over the next few months. If we could go to the next slide, please. And interestingly, if you look at regulation, which has already been touched upon, you could see there's some of the bigger initiatives. Canada and the UK are pushing through with new draft AI regulation in the pipeline. But these are the most interesting ones, I would say, that give us food for thought. And I'd really like to focus on the EU AI Act in a second. If we go to the next slide, please. I mean, common principles across all of these initiatives, self-explanatory and has been touched on already. We've done our analysis: privacy and data governance, transparency, fairness, human oversight. We don't need to say too much more about that. It's been covered. If you go to the next slide, if you don't mind. Now, this is very interesting, and I need to give a lot of credit to Stanford University. If you haven't had a chance, do look at their freely available resource where they're tracking an index of what's happening in AI. This is very interesting. What they did is they took all the requirements out of the draft EU AI Act, and on a scale of 1 to 5, they ranked various foundational models, how they performed. Now, what's interesting is that when it comes to transparency requirements, so the requirement is to make publicly available a summary of the use of training data protected under copyright law, failed miserably, as you'd expect. Really low scoring there, so no surprise there. And as I'll mention later, if you look at the response of the publishing world generally, they're unanimous in saying that there should be some kind of license, should be some kind of compensation for using content for training. Whether they'll get that or not remains to be seen, but that's very much the position. So this is very interesting research I'd encourage you all to look at. If we go to the next slide, please. And the next slide after that. So how has ISO responded? Well, there's two ways that we respond to this. The first one is to say that we have a joint committee with our colleagues at the IEC, which is SC42 on artificial intelligence. And that's responsible for developing AI standards. And that includes foundational standards, industry-specific standards. But in any case, this is bringing together stakeholders from all over the world and to look at AI governance holistically. How can we realize the opportunities? How can we mitigate the risks? If you go to the next slide, please. So this gives you an idea of some of the areas of work. And I should say that the chair of SC42, Wael William Diab, is very much the rock star of AI. Forgive me for the plug here. His committee was the winner of the Lawrence Eicher Award for Excellence in Standards Development. We consider them one of the most proactive committees we have at ISO and very much producing some really interesting standards. If you wouldn't mind going to the next slide. If we're talking about opportunities in AI, improved decision-making, advancements in various sectors, etc., we have standards that have been published which help with that. There are standards that talk about use cases. Where can you actually use AI in an effective way? Defining the concepts, application of AI in particular industries like health informatics. So we have standards that help you to realize the opportunities. If we go to the next slide, please. We also have obviously standards that help with mitigation of risk, trustworthiness, bias, guidance in AI risk management. The most interesting one that we have in the pipeline is management system standards, which is very interesting. And I would encourage anyone that wants to get involved in the work of SC42, the links at the end, please do visit the website. You're free to comment on any of the standards in development. You're free to join any of the committees. And also there are free events, workshops throughout the year that you're more than welcome to join in and listen to some of the discussions. But these are standards that can very much help us within ISO with our standards development and help the wider community. If you wouldn't mind going to the next slide, please. In terms of our response, we were, we have a SMART program where we're looking at making standards machine readable, and we're looking at structured XML first authoring of standards. So we were as surprised by anyone with all the hype surrounding AI, and we had to rethink or incorporate the latest thinking into our digital evolution projects. The first thing we did in July is that we issued a letter to the chairs and the committee managers on good practice for mitigating risks, and the general counsel at ISO, the general counsel at our counterparts in IEC, we all unanimously agreed that it was much better to be cautious here. We were not comfortable with putting our copyrighted material in any generative AI tool. We're not comfortable with the output of that being used. So we pretty much said, guys, be very careful. Do not use that. We don't mind you using these tools for brainstorming, for making sense, but certainly do not use it for actual drafting. So that letter was out, and we took that very seriously. In terms of our risk management framework, we looked at the 17 risk categories that we have as an organization. We identified 7 that are most impacted by AI, and we're looking at an ongoing mapping process. Interestingly, of those 7 risks, aside from the obvious ones, whether you're talking about IP and copyright, one of the risks was the risk of falling behind, the risk of not leveraging the benefits of AI. So that we're mindful of the fact that we have to be careful, but we have to also not miss the boat here. One of the things we're doing as part of our operational excellence program, before you even, people keep asking us, what tools are you using? What are you going to be doing? What's new? We're mapping out our entire standards creation process from authoring through to publishing, and we're looking at all the pain points. We're looking at how long it takes to do particular tasks. But for us, we see AI doing simple tasks well. Can it help our editorial team with tagging? Can it help with checking a reference? Can it help with a bibliography? Can it help with checking a formula? So for us, we see it as helping with very discrete, specific tasks. And that's the kind of research we're doing at the moment to see which of these tools could add value. So we're talking about assisted research, translation, tagging, editing, semantic enrichment. So these are areas where we feel AI can make the difference. And if we go to the next slide, please. I've included here various links that you could use about SC42, and also some links about how the publishing industry has responded. I'll read the UK Publishers Association has sent a letter which is publicly available to the UK Prime Minister as part of the AI conference the UK is organizing. And it's just interesting in light of the presentations earlier. We asked, this is just a paraphrase of the letter, we ask that your government makes a strong statement to make clear that UK IP law should be respected when any content is ingested by AI systems, fair, and the license obtained in advance. The training of AI systems should be done transparently with the consent of and in a manner that credits and fairly compensates the creator or IP rights holder, in other words, under license. In light of what we're saying, is that wishful thinking? Perhaps, but this is really the official position of publishers throughout the world, and this is where they're going. So in terms of balancing risk and opportunity, we're very much looking to our own standards. We're looking lessons learned from the publishing sector, but ultimately we're looking to incorporate AI in the standards process, but we're looking for small specific tasks. We don't envisage using generative AI tools, not yet, to actually draft the standards. However, I will say that our colleagues at IEC are experimenting with LLMs. Our colleagues in Standard Australia have actually rolled out a pilot project using a chatbot. So watch this space, but we're doing it in a careful way. Thank you.
Thank you, Hussein. That was great. I think we got a good cross-section of presentations there, ranging from those who are attorneys who represent standard associations, those like we just had from Hussein, someone on the international side, on the policy side and copyright side here with Jonathan Ban, and obviously from the standpoint of where's the Copyright Office in terms of copyrightability of standards. I'd be remiss if I didn't take this point to give you an example. We've been talking a lot that's in theory, a lot about what may be happening, but we thought it might be good to just show you one example of what happens when you ask probably the most popular AI tool out there, ChatGPT, the question of write me a standard. So if you all would there on the tech side, let's give this a shot of showing what happens when we ask, write me a standard for a lock. Okay. So here is an example where you can see on ChatGPT 4, the most recent model or version of ChatGPT, we asked a simple prompt or question, write me a standard for a deadbolt lock. And you get a pretty interesting answer, pretty detailed answer. And if you don't mind, maybe just scroll through that slowly. I'm not going to read it all, but I want to give everyone a chance to sort of digest and see this. So you've got segments, it gives you an outline, it's rendered in a way that people are used to seeing standards. It covers scope, terms and definitions, material requirements, operational, installation, security requirements. It goes into durability requirements, testing and certification, all the way down to covering areas like user manual, packaging, compliance, revision, even providing some notes. And if you go further down here, we even add a follow-up question. Let's see if you scroll, I think if you scroll to the, yeah, scroll just a little further. So while they're working on that, think about some of the things that we talked about here today about how accurate are results that come out of a generative AI tool. This looks convincing to most people. It looks like it's something that clearly a generative AI tool can do. And what's intriguing about this, if we step away from sort of where most of us are from the standpoint of being an expert in some field or even being an expert lawyer, you can see how easy it is in using any of these tools where anybody using it can say, this is so user-friendly, I can spit out standards, I can spit out stories, I can spit out artwork, and how quickly it can be used in that way. Now, obviously, we're still in an emerging technology situation where you don't know, as was talked about very clearly up here, whether it's hallucinating or giving you something accurate, but you do see the power of it and how quickly it's able to do that. The average person's not going to be able to write something that fast and render it so that people could use that. To kind of address that question of where does the information come from, and this is kind of funny, I think back to the legal case that was talked about here earlier today and some of the lawyer or gallows humor there. If you're already in trouble with the judge for using ChatGPT, probably the second worst thing you can do is double down on it and then ask ChatGPT to like give me or verify the sources you used. But here, just to give an example, we said, can you tell me, or can you tell where you sourced the information needed to write the deadbolt lock standard? And here, I think it gives a pretty good answer. It comes up with a disclaimer at first. It says, I didn't source this from any external or specific standard. It gives you kind of a caveat that this is something where its knowledge is limited up to January 2022. And it even mentions some of the organizations that we know and love here in terms of where you go for actual standards. So I do give the tool in this case some credit for kind of knowing its limitations and giving you an answer in terms of where you might find actual specifications. But we thought this would be an illustrative example to show you literally what can happen if you were to ask ChatGPT a question. You'll see further down where we kind of go a little further into it, where it says, write me a standard for a deadbolt lock that complies with New York rules and regulations. And that's a little bit more specific. That's the kind of prompt where after you've already asked a few prompts and it's got something to build on, you're going to get more detailed information. It's going to pull from New York rules and regulations and give you an answer to that question. So I think we can always talk about things in theory or things hypothetically, and certainly from our viewpoints as experts in different areas, but there's no substitute for just playing around with the tool itself and seeing what it can do. Thank you. With that, we're going to move to our moderated Q&A section. We've got some questions for our panelists here. Questions that I think many of you all might share as well for them. But we'll start here with Jonathan. And Jonathan, based on your presentation and slides, which were really interesting, I liked how you broke it down into these 3 areas to look at sort of the copyright infringement or copyright issues. Could you tell us a little bit more about how the ingesting of training data is treated in the EU and other jurisdictions?
Sure. Thanks for that question. So the EU is addressing this issue sort of in 2 parts. First, they adopted a directive. So that's basically a law that applies to the entire European Union, but then has to be implemented by each individual member state. In other words, it's, you know, the Union is directing each country to do something. And so they had back in 2018, they adopted the Copyright in the Digital Single Market Directive, and that has 2 articles dealing with what they call text and data mining. And then it's more defined that it's dealing with computational analysis relating to text and data mining. And so Article 3 requires every country to have an exception to allow sort of like this computational analysis for text and data mining for scientific research purposes. And that's Article 3. Article 4 then says, for all other purposes, you have to have an exception, but it's subject to an opt-out. In other words, if a copyright owner does not want to allow that work to be, his work to be copied for these computational purposes, he has to have he can opt out, and then the AI provider would have to not include that work in their database. So that, at the time, most people said, okay, well, that takes care of, that allows certainly the ingestion for scientific research purposes without any kind of limitation. And then for everything else, it's subject to an opt-out. But the problem is that now, as always, the technology moves and people are understanding those provisions differently. And it's quite clear that I believe the legislators did not have generative AI in mind at the time. So there is a question, does this really apply to generative AI, or does it apply to sort of the more basic forms of artificial intelligence like search or plagiarism detection or all those other kinds of things, but not specifically artificial intelligence? And that's something that will have to be determined in time. Now, the EU is also considering a new law called, and actually Hussein mentioned it, it's the Artificial Intelligence Act, the AI Act, and that would apply more requirements such as transparency. Now, that has not yet been adopted, but everyone's expecting that it will be adopted relatively soon. So at the same time, so that's the European Union, but then you have other countries, let's say Singapore and Japan, that have adopted statutes that are sort of specific copyright, that are understood to be specific copyright exceptions, allowing the ingestion. But again, it's not 100% clear ingestion for what. Given when they were written before sort of the, ChatGPT, before you had generative AI. And then there's the question is, how far do they go? Do they apply to generative AI, or do they apply to more basic forms of artificial intelligence? And that's something that will have to remain to be, that will remain to be seen. But it's certainly true that a lot of our trading partners do have provisions that at least arguably allow a degree of ingestion for AI functionality.
It's good. I got a quick follow-up. I appreciate it's a moving target, and given the breadth of different legal regimes you've covered, do you think any of that should apply here, or at least be persuasive to legislatures here?
Well, I think it has to be, because we're working in a global environment, right? And so you can imagine if, let's say, right now the Copyright Office has a notice of inquiry out concerning copyright and generative artificial intelligence. The comments are due at the end of the month, but they've already received more than 10,000 comments. I mean, they've received already a lot of comments even before the deadline. So there's obviously a lot of interest. And so you can certainly imagine Congress might say, okay, well, let's say that these cases that I mentioned and that Michael mentioned, let's say they go in favor of the AI provider. And so the rights holders say, no, we want, we think that Congress should overturn these fair use decisions, and that we should be compensated in some fashion for the ingestion. But since we're working in this international environment, it's very easy for companies to move somewhere else, and they will go somewhere else where ingestion can be done without compensation. And it's clear that some countries have, sort of as a matter of industrial policy, they want to encourage AI activity. And certainly like I mentioned, the Israeli Ministry of Justice opinion on machine learning and copyright. I mean, it was stated very clearly. It's like, we want to promote our artificial intelligence industry. And so that's why they came out with that opinion. And so, again, certainly Singapore, you can imagine, or Japan would sort of take the same approach. So as we're thinking of kind of balancing the various interests, we need to remember that, if we come out with a certain balance, that it's very possible that everything will move offshore.
Sure. No, that's a great point. Incentivize technological development. Sure.
So we have a question from Barb Jones. Is it prudent to add a message in the copyright information section of a publication that is addressed to a generative AI model that says, you are not permitted to train or utilize this content? Might this be useful in the future for when the legal guidance catches up to this issue? Will this likely provide any protection?
I'll open that up.
Yeah, let me touch on that. First of all, I don't think it does any harm, so why not include it? And second, in that Thomson Reuters case that I mentioned, the AI company actually went to Thomson Reuters and asked for a license, which Thomson declined just as a matter of policy. They don't want their work being copied. So that becomes a fact in the subsequent litigation, that you are doing this against my wishes. I'd rather have that if I'm trying to assert my copyright interests.
I would also add that I think even just including the copyright symbol would be sufficient, because it means you're asserting that it's proprietary.
And something else to keep in mind is that just like with any content, any website, you can use a bot exclusion header. You can use sort of like a do not enter sign. Until recently, the problem, and supposedly most of the AI companies, certainly Microsoft and Google, respect those bot exclusion headers. The only problem until recently was that if you used that kind of exclusion header on a website, then it wouldn't get crawled for any purpose, right? So it wouldn't be crawled for artificial intelligence, but it would also not be crawled for search, and so most people say, well, if I can't be found by Google or Bing, I'm invisible, I have to allow search. But just in the last few weeks, Google and Microsoft both have indicated that now there's like an extension. They've come up with extensions that you can put on your exclusion headers so that you can allow the bot in for search purposes, but not for AI training purposes. Now, of course, each one has its own standard, which of course then leads to standards organizations, and the W3C, the World Wide Web Consortium, needs to probably update its standard so that, you know, there's one uniform standard for how to do this that would, you know, apply to, you know, then Google and Microsoft and DuckDuckGo and so forth would all do the same, so that you could say, don't crawl for AI training purposes, but still crawl for search purposes because I want to be found.
Yeah, I was going to bring up, just to add on to that, that some of the technological development is happening right now to address that very issue. And you heard from Jonathan that Microsoft and Google are developed these extensions to allow you to do so. There's a whole tranche of other companies working on tools to allow you to do the same thing. And then kind of back to the spirit of Michael's answer, I'd say, look, that type of warning or disclaimer with the copyright symbol can't hurt. Also, because if you, and this is a little outside of field here, look at the case law that dealt with things like web scraping and just taking content off websites from 5-6 years ago. One of the factors in some of those fact patterns, and it can be different depending on the circuit, but one of the helpful facts in all those cases was where the rights owner or content owner specifically denied and said, hey, I don't consent to this, or I don't want you taking or scraping my data. That was outside of the context of AI and has had a pretty consistent reaction from the courts, at least on that aspect. Any others? I've got a question then for Ivy, unless you have any others there. So Ivy, it's a great presentation you gave us in terms of the Copyright Office perspective. There's very clear guidance sort of on what is not copyrightable, things that are solely machine driven, and then certainly discussion about sort of human involvement needing to be part of the play or part of the factors to get something that's copyrightable. Where do you see that playing out in the gray area? How much human involvement do you think you really need to have something that the Copyright Office would routinely allow to be registered?
Yeah, so I think the second example that we looked at is a good example of how much interaction you need, because there the Copyright Office was willing to grant a copyright registration on the details that, if you recall, there weren't too many of them. There were like 3 specific areas, and the Copyright Office acknowledged that because those areas were created by a human, that those could be copyrightable. The problem with what happened in that case was that the applicant was not willing to disclaim any copyright in the AI-generated content. So I think there needs to be a little bit more flexibility on the applicant side if they are wanting to register their work with the Copyright Office.
Okay, great answer, yeah, sure.
But do you think that was right? Meaning, do you think it was putting aside what the copyright, their rationale, but do you think it was right that if you had 624 prompts, isn't that enough human involvement? I mean, how's that different from using Photoshop or something to?
Yeah, so that's a good question. So the 624 prompts, I think where the Copyright Office is coming from is because the way these programs work is even though you are inputting these prompts, there's not a way for you to actually predict what it's going to generate. And the way that copyright protection exists is if it is expressed in something that you yourself conceived, but when the artist provided those, at least the initial prompt, there was nothing to say that he had already conceived of that image on his own. And I think that the fact pattern would have been better if, for example, he had drawn something out and then he had run it through the AI and said, can you do something more to this? Then I think that is the type of contribution that is necessary for there to be copyrightable authorship, at least from the human side.
Interesting. One follow-up, kind of coming at it from a different angle then, is then how should you, if you are including and trying to inform the office that you have AI-generated content, how should you include that in the application?
Yeah, so the Copyright Office actually does a good job of explaining this in the guidance that was provided in the, I think the last slide, there's a link to it. So they say that if it has AI-generated content, you can do one of two things. If you don't know exactly how to characterize what the AI generated, you can just put a note in the copyright application that this work includes AI-generated content. And what happens is the Copyright Office will then reach out to you and try to flesh out which portions were generated by the AI versus what you, as the human author, created. If you know how to fill out a copyright application and you know, like there are discrete portions that you yourself authored versus what AI generated. So for example, if you authored the text and then you used an AI tool to generate images to accompany that text, you can include in your copyright application that the human contribution of the work is the text, and then the AI generated elements are the images in that work.
Okay. My last question on that, because we've seen some examples today even, but should the user prompts be copyrightable?
Yeah, so the user prompts, they could be copyrightable, assuming that they're original and that they're sufficiently creative, which we said is a low threshold. So the tricky thing about the user prompt is that they by themselves will not extend copyright protection to the output because they're completely different, because all you have created is the text by itself and you did not create the output.
All right, thank you. I'm going to move to Michael with some follow-ups there. You went through a couple of very good issues there, and I'm curious, going back to the standard development organization side, how are SDOs currently using AI in standard development?
I think that's 2 points. Number one, I think it varies significantly from SDO to SDO. Some are not accepting the use of AI at all at this point. But the second part is if your volunteers are submitting content, you don't really know as an SDO how AI is being used. And that's the problem. If you think back to that sample standard that you put on the screen, that content was not just generated randomly. It came from someplace. Do we know where it came from? Is any of the material that it came from copyrighted by someone else? So is that use of AI to generate even just that draft infringing someone else's copyright? And even if you then take that draft and you modify it in various ways, do you still have a copyright violation because you haven't made sufficient changes? You're still using enough of the original content and you can't even claim fair use. You also have to ask, can I get a copyright on my standard given that there's some part of it where there wasn't a human author?
Right.
So that's the fundamental conundrum that standards organizations are facing today.
It is a follow-up to that. So any maybe specific advice or even just guidelines for, let's say, an organization that really wants to use AI, any guidelines that you would give to just avoid some of the pitfalls or reduce risk for them?
Well, number one, pause and think again. But I would make sure that my copyright policy is written carefully so that when a volunteer submits material, the volunteer is required to disclose that they've used AI, is required to disclose which portions are original to them and which are not. But you're not going to be able to avoid the issue that that volunteer might not make the right disclosures, and that even if they make the disclosures, their answer might not be correct.
Right, right.
And if I may, I think what that points out, Michael's answer points out that it's also worth thinking, what is it that, what should you be using the AI for? And so I think it's a lot safer if you use it not to draft the original standard, but rather to do, like the explanatory or supplementary materials after you have the standard written, meaning once you have your standard written, you plug it into, the AI, and then it will come out with summaries and explanations, which you then would have to go through very carefully to make sure that they're accurate.
Yeah.
But having the AI do that intermediate step really could save a lot of time.
Yeah, and I think it was Hussein put up the list, maybe it was you, Jonathan, of the different things that you could use AI for. Translation is probably a reasonable use. Now, you still want to know what's the authoritative version of the standard because there can be errors in the translation. And to an earlier point, as I was thinking about the use of AI as an anti-plagiarism tool, that's actually something where the copyright holders get something out of the deal, even if they're not compensated. Their work is being protected by having that tool out there.
Right. Thank you. So Hussein, I want to move to you, and I've got sort of two questions for you that kind of relate to some of the benefits and sort of the bright side of using AI. You had a good slide, and I'm not sure everyone got to see it here, and I'm going to see if our tech team, if you could go back to Hussein's presentation, there was a slide that talked about different generative AI applications, and I was hoping maybe you could talk to us about that, but give us a moment. I want to see if we can get it up.
Yeah, as I said earlier, I mean, I think when AI is a tool like any other tool that can help, and it's not a silver bullet by any means. And the best thing to do is to really map out your process and identify pain points. So if we look at the standards creation process, where are the pain points where I could help? So let's start at the very beginning. When it comes to standard creation, we pride ourselves on bringing together experts from all over the world. There's that rigor, that trust, that consensus. And one of the ways we do that is that we have very clear directives, we have very clear guidelines, we have very clear in-house styles. Now, of course, that's a lot of information for people to digest and make sense of. And remember, even people that have been working in the standards community for years sometimes forget, how do I submit a graph? What's the situation with this particular wording? So I really feel that generative AI can make a really good difference here in giving access, or let's say facilitating that access to the information you need to draft the standard. So for example, we're always encouraging committees to be more consistent in terms of terms and definitions, for example, to make sure that those cross-references, if you're drafting a standard on health, be sure that you're mindful of the related standards in insurance. So as to make sure that we connect all the communities, all those experts, they have access to the collected wisdom, the collected information that we have. So I think generative AI can make a real difference here to help facilitate cross-referencing, to help facilitate research, and just to give people access to that quicker. You're not having to think, oh, wait a minute, where's that standard I was thinking? Like, even a really good database will not necessarily get you all the information you need. So if at the beginning of the process, I really feel it's great for that exploratory phase, that brainstorming phase, looking across different standards, finding those links, finding consistency in definitions. So definitely, and also making sense of the framework you need to follow, whether it's the directives and the house styles. Generative AI can make a really big difference there in clarifying that and giving you instant access to the exact information you need. If you go to the editorial side, this is where the in-house team at ISO ensure that the content that's been drafted adheres to the guidelines, and we help make sure that the language makes sense. I want my editors to be working on making the standard the best it can be. I don't want my editors to waste time with manual tagging, checking styling, checking formatting. That's not something we want them to be wasting time on, and certainly AI tools can help with that. But as was mentioned earlier, I really feel that generative AI can make a huge difference in the explaining the standard, implementing the standard. They can really help to summarize, to help identify links between other standards. So if you look at the whole chain, that's where I see it. But I don't want to use generative AI to draft the standard. No, that's not something I want. But I want them to help people have the information to be able to draft those standards.
Thanks, Hussein. I've got now up your slide entitled, Where Can AI-Powered Tools Add Value? And here you have a good bit of visual examples of where AI applications help with productivity. I'm curious, just for the sake of the crowd, as you kind of pulled these together, it's a great visual example. Are you aware of organizations, yours, others, using AI just for these types of actions, productivity enhancement?
At the moment, there's not that many. As I said, there's a lot of people experimenting with LLMs standards. Australia, at our conference in Brisbane recently, they were piloting that. And we're actually piloting with our colleagues at the IEC. It's their project they're leading, looking at how we could use LLMs. I think a lot of people are using AI tools in the publishing sector for simple tasks. So they're not necessarily using generative AI tools for drafting. I'm talking about the big publishers here, but they're using tools to help with, as I said before, bibliographies, indexing, extracting text, formulas. So they're using it for very straightforward, simple tasks. But I definitely think it's on the radar of everyone involved. And we plan on giving guidance to our communities, all the national standards bodies next year, saying to them how they can use AI. What are those use cases? And if anyone wants to read more about those use cases, I would refer you to the SC42 standard on use cases that could help.
All right, thank you. I'm going to move back here to Jonathan, just on this issue of sort of maybe what could be done to help our legislators, legislative bodies perhaps understand what's going on with generative AI. I'm curious, just based on your experience, if you have any thoughts, just in general, how might we go about educating those who have to make decisions on what the laws are on this moving target you mentioned before of kind of looking at AI one way, but now with generative capability, how quickly things change, but also having a need to just regulate it?
Well, the most important advice I think anyone could give them is to chill, right? I mean, that this is, AI has been around for a while, right? As earlier speakers have noted, and there's already case law, as I mentioned, dealing with various aspects of AI. It's just that it's only, because of ChatGPT that everyone's sort of freaking out and the sky is falling and all the rest. And I think that there's, the number of conferences and programs dealing with AI as demonstrated by us here, right? I mean, it's like everyone's talking about it. It's definitely the topic du jour. It could very well be that within 6 months, everything will move on and there'll be a new obsession. But on the other hand, AI is not going anywhere, right? It's obviously a very useful technology, and generative AI is very useful and important. And so, I think on the one hand, everyone needs to sort of take a deep breath and not do anything rash. It's also important to sort of figure out where are the real gaps, where are the real holes. So it just seems a little odd to me that you have all of these authors filing lawsuits, somehow saying that, thinking that sort of the ChatGPT can generate something that is as good as what they do. That sounds like, sort of demeans themselves and does not recognize that their own worth and value and how much, that there is, yes, it is true that you could ask ChatGPT to generate a mystery novel, but to suggest that it's going to be anything like a Michael Connelly, Harry Bosch type procedural, I just don't think, that that's the case. And so But on the other hand, there are certain areas where I think there really will be possibilities of harm. And then we need to look at those and figure out what is the best solution. I would suggest also that copyright is a really, really blunt tool, right? And so certainly people in the copyright industry, certainly, if you're in the publishing industry, the tool you've always used in the past to deal with things is copyright, but it might not be the best tool here. And that certainly to the extent that the concern is, that photographers are going to be out of work or, and certainly you can imagine like illustrators. I think illustrators do have a lot to worry about, right? Because, and certain kinds of graphic artists, because, you can use ChatGPT or not ChatGPT, but one of the other ones that really focus on visual products to come up with pretty good animation or pretty good, if you want to add graphics to your slides, I mean, they're going to do a really good job at that. And so that is going to, displace, there will be disruption. But to suggest that copyright is the solution as opposed to something else, I think that's where actually often the EU is sometimes better at that, as sort of, they understand that certain things as a matter of cultural policy, they're going to deal with it as cultural policy. So, the whole film industry in France is all government supported. But they've decided as a matter of cultural policy, they're going to spend money on it. And, maybe just getting back to the earlier panel, maybe as a matter of cultural policy or industrial policy, we have to decide, maybe we need to give more money to SDOs. If the court decisions really do, have an impact, the copyright decisions that we were talking about in the first panel. But maybe the solution isn't copyright law. Maybe copyright was never the right solution. Maybe there's another solution that's more appropriate.
Right. Other thoughts here on the panel? I'll just move down on that particular issue. Ivy?
So your comment about artists really being affected really resonated with me. And I think that might be why the Copyright Office is taking this position, at least with the works that we saw where they said you have to disclaim any copyright in the AI-generated works, because then I think that adds value to the human artists.
Thank you. Michael? Okay. Hussein, any other thoughts on that topic?
Just reiterating that anyone that gets involved in the standards development process, that joins the committee, we'll need to make sure that our policies are very tight and that people understand that ultimately they have to have done their due diligence here, and they have to be mindful of that. But I do agree, copyright is a bit of a blunt instrument, and we need to be more creative in our thinking with this.
Thank you. I have a follow-up for Ivy. You mentioned the Copyright Office and that situation where it seemed, I think, probably to the outside observer, the Copyright Office was a little harsh, in that response saying, well, hey, you should have disclaimed it. Maybe walk us through, are there procedures if you're in that kind of scenario? Are there things you can do after the fact to correct your form or your application?
Yeah, so the Copyright Office does offer a way to correct an already registered work if you happen to file a copyright application and it registered without anyone, including the Copyright Office, knowing that there was AI-generated content in there, and it's through the supplemental registration form. So what you would do is you would just fill that out, and that you'd indicate on that form that the work does include AI-generated content. And effectively, what that would do is the original registration would no longer take effect and would be supplemented by that later registration that says that there's no copyrightable aspects in the AI-generated portions of the work.
Thank you.
If I may add to that, just putting that into the standards context, the engineer or other volunteer is going to be adding something of value. and that portion is copyrightable. But how do you know which portions are and are not copyrightable? So how would you take advantage of that available process if you just either can't get to the information or it would be enormously costly?
Sorry, so you're saying that you are the developer of the standard and then you've used AI somehow to do something, and now you're trying to parse out which portions are the copyrightable aspects? Okay, so to me, I would simply state that, or I would keep a good record of what you yourself as the human author has generated, because the way the Copyright Office works is they're just going to accept your word for it, that this does include AI-generated content. So for example, if the standard is all text, then what your work would say is that there is human authorship in the text, but there's also AI-generated text. And so it's very hard for the public to distinguish which text is yours versus the AI. But that's going to come out in litigation when you try to enforce your copyright. And so that's why I would suggest that you keep a very good record of which portions were generated by you, and then how you fed it through the AI tool and what edits the AI tool then made.
Yeah, I'll just add that what's always interesting in any kind of litigation, whether it's before the Copyright Office or anywhere else, is, looking at the whole litigation history, and you understand, then when that gives you additional insight into what's really going on. And it really seems that in a couple of those cases, certainly the Paradise one, that then went to the district court here, and then, or the other one that's the, kind of like that space age portal one. In both cases, it really seems like the applicant was being really difficult, right? In the Paradise one, the applicant was insistent that it was entirely generated by the AI, that there was no human involvement whatsoever. And then only later on, once the Copyright Office rejected it, and it was rejected in the internal appeals, and then when it got to the district court, he says, oh, no, I had some involvement. And basically the judge said, you can't do that now. I mean, when you earlier on, before the Copyright Office, you had 2 rounds, you had plenty of opportunity to correct the record, and you chose not to. You were insistent that this was entirely created by the AI. So you can't come to me now and say, no, I had some human involvement. And it's the same thing with the portal one. I mean, that the author seems completely unwilling to disclaim any of the AI-generated stuff. And so I think when you're being really difficult and refusing to do anything, you're gonna, it's not gonna work, especially as you indicated that you don't really need to disclaim anything in great detail. I mean, it's just like a sentence saying, oh, there's some stuff here that was, AI-generated, and that's probably gonna fly. That's gonna be good enough to get your registration, and then, as you say, you worry about it in litigation if it comes to that.
And I'm sure that all of the executive directors of standards organizations in this room are thrilled at the prospect of having a litigation budget. But the other practical question, and I know this from having responded to a lot of non-party subpoenas for a standards organization, the standards organization doesn't always have the records. Right. It's the volunteers. So to say, figure it out in litigation, that's an enormous problem.
It's a great point. So from a practical standpoint, not only when we're talking about an individual creator, Ivy, as you showed us in some of these great cases with creatives, but an organization like an SDO would be useful to have some type of guideline or policy that everyone using AI tools is keeping track of what was done with AI, what did they contribute, and kind of give that organization a sense of what was done. Or, as you talked about, Ivy, you may be in a situation where you've got to correct something after the fact, if you're trying to assert copyrightability over it. Okay, well, we're getting close to the end of time. I think we've got maybe 2 minutes, so I want to see if there's any other questions that are out there. I see, right here, yeah.
Is this on?
It's on.
Brad Wilder from AMP. We're a traditional SDO, and I think that point is well taken. We have several hundred volunteers in our program, and we can make a policy to say, okay, don't use generative AI to draft a document. But they also have grammar checkers. They have AI tools in Word. There's a substantial, there we go. There's a substantial amount of AI involvement in generating that content, and they might not even think about that as being an AI. So if we were to ask them, are you using AI to generate this content? Well, no, I'm just using, Clippy the paperclip in Microsoft Word. But it's really a lot more than that. And I think that's going to get even more prevalent as these tools get better and get more embedded into the tools that they're using. So I wonder if there's a difference there. Is there some safe harbor that this is not originating from the AI is just helping us improve this document?
You take a shot?
I don't think there's any current case law that provides much guidance. The DC District Court did say that at some point, AI is going to be viewed as a tool similar to a camera. And so where I think the AI tool, where you enter prompts and you can predict what the AI tool is going to do, I think that it is more that favors the side that it is human authorship, but where you have no idea what the AI is going to generate, I think that puts it more on the side that it's not going to be copyrightable. And I also wanted to mention that Thaler did just file a notice of appeal with the Federal Circuit, so this is not yet finished, so there might be more to this.
Great question. I think we're out of time. Oh, we got one more?
Yeah, just one more question on that same subject, because we're talking about human-generated content. If we have 100% human-generated content, but we use artificial intelligence, right, not necessarily generative AI, there has to be a difference, right? We're using artificial intelligence to edit, to rearrange, to put commas where they need to go. That is entirely different than using generative AI, right? And so as long as we have 100% generated content and we're using AI efficiency tools or editing tools, some of these things aren't even really AI, Microsoft, spell checker, all that kind of stuff. So I just want to make sure if all of our content is human created and we're using AI to make it pretty, that we're not talking about pictures, but we're using AI to make it editable and publishable, that's fine.
Yeah, that's our position as well. These are tools to help us achieve that, so that's okay.
Yeah, there's no one who owns the copyright in the Oxford comma.
All right, thank you.
Great, thanks so much. Thanks, everybody, for joining us today for this great discussion on the complexity and nuances of copyright implications in our evolving world. And a special thanks to our keynote speaker, Professor Carrie Colanisi, for setting the stage, to our moderators, Kevin Fee and Justin Pierce, for skillfully guiding the panel discussions. And finally, thanks to our distinguished panelists for joining us from all over the globe to deepen our grasp on these issues. We set out today for panel one to bring together SDOs and government agencies to start a discussion on IBR in some meaningful way. And I think we succeeded in starting that dialogue and beginning to identify some old solutions, some new solutions, some partial solutions, but we're on our way to developing some really important thinking on that. And as for panel two, our goal was to sensitize everyone to the use of AI in standards development, and identifying the right balance of risk and benefits. And I think we did that too. The dialogue will continue, and I look forward to doing that with so many of you. As I said earlier, for those seeking CLE credit, if you're here in person, make sure you sign out at the registration table. you don't need the code word. But if you're seeking CLE credits online, please type your full name followed by the code word copyright into the Zoom chat now to verify your attendance. Again, the code word is copyright. Again, if you're seeking CLE credits online, please do that now and type it into the Zoom chat. For those of you here in person, many of you know that tonight ANSI is hosting the U.S. celebration of World Standards Day. That begins at 4:45. It's a reception format. It's at another spot in this building. The folks at the reception desk can tell you about that. Tickets are still available on our website, and you can also seek some help from folks at the registration desk. So we look forward to seeing you all tonight, and thank you so very much for coming.